Please, Lordship.
Yes.
Lordship, I beg to mention item number 32.
32.
32.
30.
32. I have an instruction to withdraw the matter, Lordship. The petitioner don't want to pursue the matter. So I may be allowed to withdraw the matter.
Okay. What happened?
Lordship.
What happened? Why you want to withdraw the matter?
Lordship, the financial bid has already opened. And as for the comparative statement has already been circulated. So as for that comparative statement, even if he allows by this honorable court, he will not be L1, Lordship.
Okay. Okay. Mr. K. Lolan, learned counsel for the petitioner, submits that he has the instruction to withdraw this petition. Accordingly, taking note of the submission of Mr. Lolan, learned counsel for the petitioner, WPC number so-and-so is thus disposed of on withdrawal.
Madam,
Yes.
my name will be kindly reflected for respondent number 3, madam.
Okay. Mr. R. Saikia, learned counsel for the respondent number 3, present.
Right.
May I pray that item number 22, this may be taken on 7th, 22,
22 at
7th of April.
7th of April.
Yes, I have to take some instructions. I have taken consent.
Okay. Item number 22.
22.
You have for respondent number?
Respondent number 1, 2, and 3, my lord.
1, 2, and
State respondents, my lord. My lord, may record state respondent.
Mr. N. Rotten, learned additional advocate general with consent from the other side, as for listing the matter on
7th of April.
7th of April.
Oblast. Oblast.
My lord, I beg to mention item number 35 of today's issue, your lordship. My lord, leading counsel is out of station, and I have taken consent from other side also, your lordship.
You have for the petition.
Petitioner, yes, my lord.
Mr. Your name, please.
K. Kyoda Moses,
Learned counsel appearing on behalf of Mr.
H. Lampu.
H. Lampo, learned conducting counsel for the consent from the other side, first for listing the matter after
1 week.
after 1 week.
And your lordship, there is another matter is item number 38 and 39.
Yes.
It may be listed on same after 1 week,
From
lordship.
the other side.
Petitioner, yes, lordship. I have
Okay.
taken consent from other side.
We are appearing from the respondent number 5. We had taken this date. We want to argue this matter today itself.
Pardon?
I'm for the respondent number 5 from item number 39.
Okay.
We wanted to argue this matter today itself. We had taken this date before, sir.
But the conducting counsel is absent after 1 week.
After 1 week.
Yeah.
Okay.
So do you fix it?
Yes, sir.
Suggested it?
Yes, lordship.
Suggested it? What did you suggested
Give me a
it?
specific date which you available.
I'll consult my seniors and fix the date with the court itself later.
Pardon?
I'll consult with my seniors and fix the date later.
In the month of April?
Yes, yes.
Okay, your
When Mr. Lampo will be available?
lordship, as per his instruction, he will be available after 1 week, your lordship.
After 1 week.
Hmm.
Then 6th of April?
Works.
My lord, 6 will be Monday.
Yeah.
Let it be 8.
8. Okay.
8 April. I'll consult my seniors.
Okay.
Thank you.
Okay, deeply obliged, your lordship.
Lordship, I would like to mention item number 26, your lordship, and 27.
26 and 27.
Yes, your lordship.
Both.
Yes, both, your lordship. May I kindly fix this matter in the next week, your lordship.
Ms. Basar, learned government advocate with consent from the other side, first for listing the matter
Yes,
after,
After a week, your lordship.
after a week. Fair look.
Lordship, and another matter, item 37, your lordship. 34, your lordship.
Yes.
After a week, your lordship, may kindly this matter may be fixed. After 2 weeks, after 2 weeks.
Ms. Basar, learned counsel for the respondent, state respondent. Learned government advocate appearing for the state respondent with consent from the other side.
Yes.
For listing the matter after 2 weeks.
Lordship.
Spare allowed.
Obliged.
Your Lordship, I beg to mention item number 24. I'm appearing on behalf of N. Dungan. She's a conducting counsel for the petitioners. She could not be here because she's on leave. So this matter may be kindly fixed after 3 weeks.
Okay, Mr. Your name, please.
J. Nino,
Learned counsel appearing on behalf of
24.
Mr. N. Dangan, learned conducting counsel for the petitioner with consent from the other side. First for listing the matter on
After 3 weeks.
after 3 weeks. Spare allowed.
Much obliged.
My lord, I would like to mention item number 36. The respondent 1, 2, and 3, they file affidavit and reply. So matter may be fixed for hearing after a week. I am for the petitioner.
Okay,
I have received the copy, reply file the respondents.
heard Mr.
Titorum.
P. Toram, learned counsel for the petitioner. Mr. N. Taze, learned counsel for the respondent number.
Three.
Respondent number 2.
My lord, two. Sorry, my lord,
Number 2.
two.
Mr. Tarum, learned counsel for the petitioner submits that the petitioner has filed affidavit in reply.
Yes,
And
I have
as such,
received
the
the-
matter may be listed for admission hearing. Accordingly, it is provided that registrar lists the matter for admission hearing after
week,
after a
after
week.
a week. Highly obliged.
Registrar lists the matter after a week.
Item number 1.
May I please?
Yes.
My lord, the grounds, my lord, on which selling the impugn order, whereby
No,
part
on the other day, we were
my lord,
supposed
I will
to-
second appeal that I will come. My lord.
Yes.
So first start with few grounds, my lord. Then
No, not necessary. You show me
Okay.
the judgment.
my lord, my lord. My lord, first 2000. My lord, this 2011-15 SCC, my lord.
Mm.
Here the apex court has deal with all the issues and says, my lord, this statutory appeal, my lord.
Mm.
This first appeal, second appeal,
Mm.
this all have to be, my lord, since it is explicitly provided under the act and the rules, my lord.
Which is the relevant?
My lord, I start from para 40, my lord. Para 39, para 40, my lord. It is so well known that when a procedure is laid down statutorily and there is no challenge to the said statutory procedure, the court should not, in the name of interpretation, lay down a procedure which is contrary to the express statutory provision. It is a time-honored principle as early to be done in a so and so. Then para 41. Then my lord, para 47 also, my lord. Then 49 also, my lord. In this case, my lord, in this case, the petitioner, without exhausting the this appellate, my lord, this avenue, my lord, directly file the complaint under section 18 to the Information Commission. So under that context, my lord, this entire aspect has been dealt. My lord, we'll see section, my lord, 19, 2 of the Act says, my lord, that second appeal is against the order passed by the first appellate authority, my lord. It is very explicit, my lord, this provision. My lord, one another provision, judgment, my lord, of the Delhi High Court, my lord, where, my lord, this, when second appeal was not filed, then Chief Information Commission rejected that order has been upheld, my lord, that other judgment. Ved Prakash. Yes. Your Honor, para 10. Ved Prakash Agarwal, Delhi High Court, my lord. Para 10, my lord.
First appeal is to be filed before whom?
First appeal, my lord, it has to be filed before the senior officer to the information officer. It should be deputy commissioner, my lord.
Department.
My lord, deputy commissioner, yes, my lord.
Yes, Mr. Soika.
That is there, my lord. Okay, my lord, one provision cannot be, my lord, bypassed, my lord.
Okay.
There is a provision, my lord.
And
And
Mr. Arsonar, learned counsel for the petitioner, Mr. Soikia for the respondent. For all the respondents, Mr. Soikia.
for one, my lord. No, I don't.
In this petition under Article 226 of the Constitution of India, the petitioner has challenged the order. Dated 6/2/2026, which indicate Annexure 1 passed by the State Information Commissioner APIC in case number APIC-764/2025. Insofar as it directs the petitioner herein to furnish information pertaining to serial number 4, 5, 8, and 9 of the RTA application dated 27/6/2025. And also challenge the so-called notice dated 6/3/2026 issued to the petitioner under section 28(1) of the Right to Information Act 2005. And also right for issuing direction to the respondent authorities. Right for issuing direction for quashing case number APIC 764/2025. And also for declaration that information relating to land acquisition for the frontier highway, which indicate NS 913 being a defense strategic infrastructure project requires under section 40, which indicate 1 and 4 of the RFCT LARR Act 2013 is exempted from disclosure. Under section 8, which indicate 1, which indicate small a of the Right to Information Act 2005. Mr. Sonar, learned counsel for the petitioner, submits that the petitioner is the PIO cum District Land Revenue and Settlement Officer, Paling of Kadadri districts. And by impugn order dated 6/2/2026, the State Information Commissioner APIC in case number APIC 764/2025 has directed the petitioner herein to disclose information at serial number 4, 5, 8, and 9 of the RTI application dated 27/6/2025 and also issued so-called notice dated 6/3/2023 calling upon the writ petitioner to show cause on 1/4/2026 as per why penalty of rupees 25,000 should not be imposed under section 20, which is bracket 1 of the RTI Act 2005. So sooner further submits that the information which was directed to be provided by the Information Commissioner relates to land acquisition for defense strategic highway project, specifically the Frontier Highway, NH 913 of Puri-Taliha Straits, when such disclosure is prohibited by a binding government circular and exempt under section 8, (1), small a of the national security, and section 8(1)(j, third party privacy of the RTI Act. And the petitioner herein has withheld the information at serial number 4, 5, 8, and 9 of the RTI Act of RTI application dated 27/6/2025, comprising bank account details and compensation particulars of individual land affected beneficiaries, on the ground that the Frontier Highway is a defense strategic project acquired under section 40(1) of the Act of 2013. And that the acquisition affect the sovereignty and integrity of India covered by the national security exemption under section 8(1)(a) of the RTI Act and by circular number SCCY, which indicate LM-06 of 2021, dated 15/3/2021. And the financial data of the beneficiaries is protected under section 8, which indicate 1, which indicate J. Mr. Sonar further submits that the State Information Commission, by the impugn order dated 6/2/2022, has also directed the petitioner to disclose the withheld information, ignoring the national security exemption, and also issued so cause notice dated 6/3/2023, threatening penalty of 25,000 under section 20, which indicate 1 RTI. Mr. Sumner further pointed out that the petitioner has preferred the second appeal without exhausting the procedure of filing of the first appeal, and referring to a decision of Honorable Supreme Court in the case of Chief Information Commissioner and another versus State of Manipur and another, reported in 2011-15 SCC, page number 1, and also the decision of Delhi High Court in Ved Prakash Agarwal versus Deputy Registrar, which indicates here as 1, Central Information Commission, reported in Mono /DE/0800/2020, submits that without filing the first appeal, the petitioner cannot. The respondent number 1 or 2, respondent number 2, respondent number 2 cannot directly file the second appeal. In view of section 19,
19(2), my lord.
19(2) of the Right to Information Act.
And rule 10(2).
Rule 10(2) and 3.
my lord.
2 and 3.
19.3, my lord, 19 subclause 3, then of the Act, my lord, and Rule 10.2 and 3 of the Right to Information Rules
Right to
2012.
Information Act. And since the impugn order was passed in contravention of the aforementioned provision, and also so cause notice was issued to him threatening to impose penalty of rupees 25,000. The said order and the notice suffers from illegality, and the same requires interference of this court. And therefore, Mr. Sooner has contended to consider the pair made in this writ petition. Mr. Soikia, learned standing counsel for the respondent number 1, also submits that the petitioner submits that the respondent number 2 herein preferred the second appeal without preferring the first appeal before the concerned appellate authority. The submission of learned counsel for both the parties needs further consideration.
So may I pray this, my lord? Let my lord may stay this my proceeding, my lord. But my lord, let them file an application before the commission apprising this fact that my lord, the information seeker has bypassed one appellate forum, my lord, and filed directly second appeal before the commission. They let them file an application, my lord, before the commission also, my lord, to refer back the matter to the first appellate authority, my lord. In the meantime, my lord.
Will dispose of this petition?
My lord may not dispose of, my lord. Well, if my lord grants interim order, my lord, in the meantime, they may also apprise the commission, my lord, regarding the bypassing of one appellate provision, my lord, by the commission, my lord.
Who will
By they will file one application.
present petitioner?
Yes, ma'am.
Or we can dispose of this petition also.
With that direction, madam.
Mhm.
Yes, madam. Nah.
Any objection?
No issue, it can be discussed also.
No, the fact is that, of course, one issue is there, whether the circular relied upon him
Yeah.
covered the case of the petitioner or not.
That cannot be, my lord, relied upon, my lord, because, my lord, section 24 of the Act, my lord, is a overriding, my lord, set provision, my lord.
Section
24 of the Act, my lord. It overrides, my lord, other provisions of the law, my lord.
That matter needs examination, my lord, because the undisputedly land has been acquired by invoking section 40 urgency clause, my lord. And section 40, and there a declaration also, land has been acquired for defense strategic purpose. In that situation, my lord, now issue.
Mr. Sonar, you see, apparently the circular does not.
Sir, I will not, my lord, insist on circular now. Section 40 of the Act itself says, my lord, this land has been acquired under section 40.
No, that urgency clause can be invoked anywhere.
Yes, my
Not
lord.
only in defense project.
Yes, my lord. Then once, my lord, and this is for defense purpose, in the declaration under section 19 of the Act also says that this is particularly for defense purpose, my lord. That declaration.
But, merely because the land was acquired invoking the urgency clause, you are not entitled to protection.
My lord, that matter requires examination. And another issue also, my lord, because bank details, this comes under personal information, my lord. Then there is
third-party information, of course.
Personal info. Then, my lord, here what happened, my lord, this necessity has not been taken into consideration whether any public interest supersedes for the disclosure of information. But law mandates, my lord, that particular satisfaction.
Let us do one thing. Let notice go at this. In the meantime, we will stay.
My lord, matter needs examination.
The submission of learned counsel for both the parties needs further consideration. This is a notice be issued to the respondents. Returnable in 4 weeks. However, no formal notice is required to be issued since Mr. Soikia entered appearance and received notice for respondent number 1. However, extra requisite copy of the petition be furnished to him during the course of the day. Step upon respondent number 2 be taken by speed post and also by usual process within a week from today. List after 4 weeks, and further considering the submission of Mr. Sunar, learned counsel for the petitioner, and also the submission of Mr. Soikel, learned counsel for the respondent number 1, and further taking note of the fact that the second appeal was filed without referring the first appeal. A prima facie case appears to be made out in favor of the petitioner, and accordingly, the impugned order dated 6/2/2026 and the notice dated 6/3/2026 then state till returnable date.
Deeply.
List after 4 weeks.
List after.
Item number 2.
List after.
This writ petition, this is in fact the third writ petitions that I have been compelled to come before this honorable court, Lordship. First writ petition, Lordship, was filed, and there is an order, Lordship, from this honorable court. Lordship, it find that order at page operating. It's at page 61, Lordship. This is WPC 63 of 2026, Lordship. Now here we have challenged the election process, how the election was conducted by the Arunachal Cricket Association, Lordship. Now there, the Lordship has clearly observed in the last paragraph, Lordship, page 64, Lordship.
Yes.
Considering the submissions of the learned counsel for the petitioners and prima facie the constitution of the Arunachal Cricket Association in respect of preparation of electoral roll as well as the appointment of electoral officer appears to have not been followed. It is hereby provided that the AGM election of the Arunachal Cricket Association proposed to be conducted on 24/2/2026 shall be subject to the outcome of this writ petition, and if the AGM election is conducted, same be conducted in accordance with law.
Whether that writ petition was disposed of or
No,
not?
Lordship, it is still pending, Lordship.
So why don't you file one IA in that writ petition?
Lordship, another writ was filed, Lordship. The election was conducted, but it was not done as per law, Lordship. So another writ petition was filed. That is also pending, Lordship. Lordship, page 65. WPC 97 of 2026, Lordship.
What was that?
Order is at page 69, Lordship. Order is at page 69. This is of 12/3/2026, Lordship. Heard so-and-so learned counsel for the petition who submits that the filing this writ petition, the petitioners are challenging the declaration of results of the election held for the various posts of office bearer of Arunachal Pradesh Cricket Association dated 24/02/2026 on the ground that the same is in gross violation of Constitution of Association, more particularly clause 13C, wherein it is specifically provided that any office bearer who has held any post for 2 consecutive terms in either in association or in BCCI, in combination or both, shall not be eligible to contest any further election without completing a cooling off period, 3 years. The learned counsel submits that the term of the office bearer is 3 years, and most of the private respondents have already been an office bearer of the association for 2 consecutive terms, and therefore they are not eligible to contest the elections. Here in this elections, that cooling off period has to be mandatorily followed. So many office bearers who are again contesting in the elections, their tenure of 6 years was already completed. That cooling off period they did not comply with. The learned counsel further submits that when the petitioners found out that an election was contemplated without appointing an electoral officer, that in the initial writ petitions we have contended this also, Lordship. They have not appointed an electoral officer. They approached this court by filing writ petitions, which order I have read out, Lordship, WPC 63 of 2026. This court by order dated so-and-so, taken into account the projection made by the petitioner, directed the election being conducted will be subject to the outcome of the writ petition. The further court further directed that if the election is conducted, the same should be in accordance with law. Following the above directions, the respondents, for the sake of formality as an eyewash, engaged the respondent number 10 as the electoral officer for 1 day, the day of the elections. Referring to Rule 36, subclause 1 of the Rules or Regulation of Association, the General Council submits that the requirement is that electoral officer has to be appointed at least 4 weeks prior to the annual general meeting at which an election is to be held, and who shall be former central or state election commissioner. He submits that the said provision has not been adhered by the respondents. He submits that the notifications of the association have been issued by the honorary secretary of the association and not by the electoral officer. In this connection, the learned council refers Rule 36 subclause 2 of the Rules and Regulations, which provides that the electoral officer shall oversee and supervise the entire electoral process, including the scrutiny of the electoral roll for the FX Council, which shall include all nominations and candidatures being subject to his scrutiny in accordance with the rules. The learned council therefore submits that the election process as well as the declaration of results dated should be set aside and pending final consideration of the writ petitions. The result declared on so-and-so shall be stayed. In support of his submissions, the learned has referred to the case of so-and-so, so-and-so. In view of the above issued notice motion reasonable, having regard to the projection made prima facie, Lordship, this is important, having prima facie appears that the relevant provisions in the constitution of the associations and the rules and the regulation have not been adhered to, and therefore the impugned declarations of results 24/2/2026 is stayed till the next returnable date. Now the election result was stayed accordingly. Election result was declared on 24/2/2026. That was stayed in this writ petition, Lordship. Subsequent two writ petitions, in the second writ petition, this was stayed, Lordship. Now, second is also very important, Lordship. Since an interim order has been passed without hearing the respondents, they will be at liberty to seek modification, alteration of the interim order, Lordship. That opportunity was given to the respondent, Lordship, for any further modification and alteration of the impugned this stay order that has been passed by this honorable court, Lordship. List the matter again on 6th April 2026, Lordship. This matter was supposed to be listed on 6th April 2026. Now, during the pendency of this particular writ petitions, we have submitted this order before the association, Lordship. Now, what the association did after receipt of this order, Lordship, page 72, Lordship. Now, this is impugned in this writ petition, Lordship. This is the past order that I am impugning in this writ petition. Very interesting, Lordship. They have come up with one office memorandum, Lordship, now. Subsequently, they have come up. They have agreed, they have received the order of the writ petition 97 of 2026, whereby the election result was stayed, Lordship. Consequent upon the verdict of WPC 97 of 2026, wherein the Honorable Guwahati High Court, Itanagar bench has stayed the election result of Arunachal Cricket Association. They are in agreement that has been stayed. It is well within the knowledge of the association, which was held on 24 February 2026. This bold letter, Lordship, this is very. The office bearers of ARCA as on 23 February 2026 is deemed to have resumed the duties and responsibilities of ARCA. Now, circumventing that the stay order, Lordship, they are saying that before the notifications was plotted, Lordship, the result notification, they say that before the notification, how it is possible, before the election result itself, they have resumed the office. How it is possible, Lordship? This will continue till the stay is vacated and the said writ petition is disposed of by the Honorable High Court. This is for information of all the concerned, please. Now, still they are functioning, Lordship. Now, after their tenure is over, Lordship, generally they become the functus officio, Lordship. Now, whether the functus officio, once they become the functus officio, Lordship, can they resume the office again, Lordship? Now, they have circumventing the stay order, Lordship. They have again resumed the office, Lordship. Now, not only resuming the office, Lordship.
No.
Page 73.
Is it correct that on 23rd of February 2026, before passing of the order by this court on 24th of February 2026, they have declared the result and assumed the search.
No, Lordship, how it is possible, Lordship? The election result is of 24 February 2026, Lordship. Before the result, how can they resume the office? They are saying that they have resumed the office on 23rd. The election result was declared on 24th. How it is possible, Lordship? After the declaration of result only, they can resume the office, Lordship. This is very interesting part, Lordship.
No, where it is stated that they have declared the result on 24th.
Lordship, so in the previous writ petition, Lordship, the result 24 to 2026 was clearly stated by this honorable court in the writ petition 97 of 2026, Lordship. The order which I've just read it.
Stated that shall be subject to the outcome of the writ petition.
No, Lordship, in the second writ petition, Lordship, that result was state, Lordship. Lordship, for my convenient, I'm reading it.
Was stayed on 23rd, 24 to 2026. That order was passed on 12/3.
Lordship, March. Now that election result is of 24, Lordship. Now they say that on 23rd they have resumed the office, Lordship. How it is possible, Lordship? It is not at all possible, Lordship. Before the election result is declared, which is stated by this honorable court, how can they resume the office?
Sir,
24th February
2026 is fixed for declaration of result.
Lordship, 24 February 2026 is the result date, Lordship.
Where it is stated?
Lordship, that is put to challenge in writ petition number 97 of 2026, Lordship, which was stated by this honorable court, Lordship. Subsequently, they have come up with this impugn order, Lordship.
Stayed on 24 to 2026. No, is it a fact that on 23rd they have declared the result?
No, Lord. On 24th only it was declared, Lordship. Result was on 24th.
What document you have to show that the result was declared on 24th?
Lordship, that is part of that annexure is part of writ petition 97 of 2026, Lordship. That is stated by this honorable court, Lordship. That election result. That
do you have that annexure?
Lordship. Lordship, I have this, so I have not printed it out since it was part of the annexures in the writ petition 97 of 2026. But I have the subcopy with me, Lordship. This is 24 to 2026.
Do one thing, you take a printout, you produce it at 2 o'clock.
All right.
2 o'clock. Or we may call for the writ petition also.
Lordship, that we can do, Lordship.
Should I fix it today or tomorrow?
Lordship, tomorrow, taking up every writ petition number 97 and
Heard, Mr. Zini, Learned Counsel for the petitioner.
63.
In this petition under Article 226 of the Constitution of India, the petitioner has challenged the office memorandum number ARCA/AP/2026/01 dated 13/3/2026, whereby the respondents herein have unilaterally and illegally assumed power as deemed office bearer, and also the notification number ARCA/AP/notify/2026/6/01 dated 13/3/2026 6, whereby various illegal appointments to the post of CEO and subcommittees were made. And also the circular number ARCA/circular/2026/01 dated 7/3/2026 regarding selective exemption from district level election. And also the so-called notice number ARCA/notice/2026/01 dated 17/3/2026 issued to the petitioner in a retaliation and unauthorized manner. Mr. Zini, learned counsel for the petitioner, submits that he relies upon some of the documents which were annexed with the WPC number 63 of 2026 and also the WPC number
97.
97 of 2026. And accordingly, it is provided that Restrictive shall list this writ petition along with WPC number so and so tomorrow
Obliged.
for further consideration.
Obliged.
Item number 3.
May Lordship. This case is Lordship with limited prayer Lordship. Kindly see Lordship this sanction order. This sanction order is at page number 17, Annexure 1. Kindly see the serial number 6. Serial number 6 is with regard to Annexure 1, page number 17 of WP. Serial number 6, repairing and maintenance work of forest, rest house, Simpu, including construction of road, boundary wall, security fencing, water tank, etc. After seeing this allocation is issued by in common order by the Commissioner Planning and Investment. Accordingly, after seeing this, I am a contractor Lordship of class 4 category. I have written an application to the competent authority for open tender of this scheme because as per this standing government guidelines under the CPWD Works Manual section 17 of the rule, every government tender has to be given an open tender for competitive bidding. So as per the relevant rule, having a contractor, this issued a legal notice. Legal notice to the page number 23 is a legal notice issued to the authority, saying that this work may be given an open tender. Accordingly, in the page number 25, Annexure 3, the authority has replied. This is the only limited contention. Kindly see there. This serial number 2 of the reply. Page number 25, Annexure 3, serial number 2 of the legal notice reply. The authority says urgent administrative requirement. So it is a case of urgent administrative requirement. There will be no any tender over the work. Kindly may I read the language. It is respectfully submitted. This office has received a communication letter, Sergeant says, Private Secretary, Government of Secretary, the Honorable Minister, Environment and Forest, Climate Change, Government of Odisha Pradesh, conveying that urgent maintenance, improvement of work at the Forest House, simply required to maintain interim accommodation of the Honorable Minister. This work indicated in the communication letter, including maintenance and improvement, renovation, extension, strengthening of boundary security wall protection, installation of overhead water tank, related infrastructure to ensure adequate water supply. So accordingly, they're saying, the authority is saying it is a case of exempted category. Whereas Lordship is aware of this tender rule. If this all work is awarded directly to the contractor of choice, it is a violation of the Article 14 of the Constitution of India. There should be a competition. Since there is standing government guidelines and government rule, since government is following the CPWD works manual that is extended in the state of Arunachal Pradesh, in which only as per this prevailing rule, only 50 lakhs of money that can be awarded without any tender, and above 50 lakhs, even if it is 1 rupee, that has to be put on tender. Urgent, unless there is an exemption certificate or approval from the competent authority saying that it is required to do so. That is why at this stage, I will be pressing for Lordship this disposal of my pending representation at this stage, while staying this awarding of this any contract against this work to anybody else, because this work cannot be executed in like manner. We are regularly paying this renewing this contractor registration every year as per rule, with an expectation of having contract work from the government department. And now government is doing, they wanted to award the contract with the already chosen contractor, which is in violation of this.
Whether the work was awarded to someone else?
No, not yet. They are saying just it is an administrative requirement, urgent administrative requirement is there. That is why they are not going to the given for open tender of the work. And even I have discussed with the authority saying that that cannot be allowed because there is an instruction from Honorable Minister. There cannot be. That is the issue here. That is why at this stage, simple direction may be given in terms of this representation.
To dispose of your representation?
Yes, representation.
Annexure 4?
Annexure 4.
Yes, madam.
Lordship may see the reply to legal notice, Your Lordship, at page 25. Your Lordship has already gone through serial number 2, urgent administrative requirement. Your Lordship may kindly see at page 26, serial number 3, Your Lordship, execution of works in urgent circumstances, Your Lordship. In compliance with the aforesaid instructions and keeping in view the urgent and immediate requirement of the government, this office had undertaken the aforementioned works on priority basis. Due to the time-bound nature of the requirement, the works were carried out as maintenance and urgent repair works, and the same were executed and completed within a required time frame. The works were therefore not prospective or proposed works, but rather works already completed prior to the representation submitted by your client. Hence, the representation dated 11/3/26 submitted by your client requesting for floating of open tender does not arise in the present circumstances because the works had already been executed by the time such representation was received. So, Your Lordship, the works were already undertaken under urgent maintenance work for official purpose, Your Lordship. So now, Your Lordship.
So, Sir Tapak, what purpose will be served?
Yes.
Kindly see, Lordship, kindly see. This allocation is on 6 March 2026, very recent. And this is such a huge voluminous work. How that can be?
And this is, Your Lordship, additional allocation, Your Lordship.
Yes, management work, Lordship.
If you see the
Nothing
letter,
else.
page 17, Your Lordship,
Completely illegal procedure, Lordship.
approval
6
is
March
hereby accorded for an
2026.
additional allocation.
And now they are replying that already work done. That cannot be, Lordship. This is a completely violation of procedure. 6 March. Now it is 25 March. And work is about 1 crore, of 1 crore project. And there is nothing, any exemption certificate. There is no such notification. Ministers and MLAs and secretary has to also follow these standing guidelines and government rule, Lordship. Minister doesn't mean they can do anything as you wishes. That is why, Lordship.
And
in that case,
where in CP manual, in which clause it is provided that?
This clause section 17, Lordship.
Where it is provided? Is it part of the record?
Every every contract work has to be given an open tender. This is
No,
the
no,
mandate of the section 17 of CPW work
Do
manual.
you have that manual?
I do not have, but that is the mandate of law.
No, you produce the same. After some time?
Can this matter be fixed for tomorrow, Lordship, so that government can also take instruction, Lordship?
Instruction,
Exactly.
Your Lordship, already work has been
Exactly.
completed. It is clearly mentioned in the reply, Your Lordship.
Exactly, instruction over the under which provision of law did this work has been exempted. That may be taken note. Because without any rule, there cannot be any exemption, Lordship. They are saying that it is exempted category, Lordship. That is the issue here. My contention, Lordship. Since I am the contractor, I have the right to participate in the tender, Lordship. Maybe matter may be fixed for tomorrow, Lordship. I will produce the section 17 also. I have the book. CPW work manual. And they may take instruction also.
Heard Mr. Tapak, learned counsel for the petitioner, Ms. Arbasar, learned government advocate for the state respondent. In this petition under Article 226 of the Constitution of India, the petitioner has paid for issuing direction to the respondent authorities for strict compliance of Section 17 of the CPWD work manual and other relevant
CPW work
provision
manual.
of law or standing norms, guidelines and rules in execution of government contract, that is CO, CC, approach road, boundary wall, security fencing, water tank, etc. And also to issue appropriate direction to the respondent authorities for disposal of the representation dated 11/3/2026 and 23rd/3/2026 with speaking order in terms of law and applicable rules while awarding government contract unless fallen under exempted category. Exempted category. Mr. Tapak, learned counsel for the petitioner, submits that where is the annexer you have enclosed here?
Section 17 is
No,
not
no.
closed. That is not, that is a rule, Lord.
No. This the work, not
Page number 17, annexure 1.
page number 17.
Yes, annexure number, serial number 6. Of 6, planning department is allocated on 6 March.
Okay. Mr.
Very
Tapak,
recent.
learned counsel for the petitioner, drawing the attention of this court to annexer 1 at page number 17,
Serial number 6.
which is an order dated 16th of March, 6th of March
6 March.
2026, submits that the planning department, that the finance, planning and investment department and planning and investment division of the government of Arunachal Pradesh has accorded allocation of rupees
1 year. 100 lakhs, 1 year.
249 lakhs
That is in general.
to the environment, forest and climate change department for the implementation of the project, including project mentioned in serial number 6, which relates to repair and maintenance work of forest rest house, Simpo, including CO, CC, approach road, boundary wall, security fencing, water tank, etc. of Papumpare district for an estimated cost of rupees 100. Then referring to annexer number, your RTI reply?
Yes. Not exactly RTI, it is a legal notice reply.
No,
Page number 25.
is
Annexure 3.
to the annexer number 3,
Three.
which is in reply to the legal notice
Serial number 2 and
issued
3.
by the counsel for the petitioner, submits that the respondent authorities in the said reply has stated that they have invoked
Yes,
the urgency clause
urgency clause.
and they have executed the work without inviting tender, open tender, which is in violation of section 17 of the
CPWD workman, yeah.
CP,
CPWD workman,
CPWD manual,
worksman, yeah.
work manual. However, Mr. Tapak submits that he has not enclosed the said manual with this writ petition and he pressed for listing the matter tomorrow so as to enable him to produce the said manual before this court. He also submits that in the meantime, the respondent, the learned government advocate may be directed to obtain instruction as to whether the under which provision the urgency clause is invoked while executing the said work. Accordingly, taking note of the submission of Mr. Tapak, learned counsel for the petitioner, it is provided that rest shall list the matter tomorrow, and in the meantime, Ms. Basar shall obtain necessary instruction as to under which provision the urgency clause is invoked in this matter, and the work is executed without floating open tender as required under section 17 of the
Lordship,
CPWD.
can it be on Friday, Your Lordship? Day after tomorrow.
Okay.
I have to communicate
Right.
also, Your Lordship.
Yes.
Of night.
Item number 4.
My Lordship, the petitioner, who is a candidate for the post of assistant professor in the Department of Social Work, in response to the advertisement number F/34 advertisement 2023 dated on 17/7/2025, issued by the Arunachal Pradesh University, Pasighat. Now, advertisement is in annexure number 1.
38.
Page 38. This is the advertisement. And come to the page 41. Note, the UGC guideline shall be the ultimate basis of reference if there is any issue with regard to the recruitment of the above mentioned posts. Arunachal Pradesh University has got no recruitment rules because it is sponsored by the UGC. So the entirety of the advertisement and appointment is to be done as per the UGC norms. The criteria for shortlisting the evaluation will be guided as per established UGC and state government guideline. Here in the advertisement, they have matched, and there were 14 candidates, particularly in social work. Then, here I have challenging the selected candidate, that is respondent number 6.
No, here you have also made allegation of biasness,
Yes,
but the members of the selection committee has not been arrived here.
they have not followed the API for listing candidates. If they followed as per the API, the selected candidate would not have been qualified to be a candidate. Say API for listed candidate. In case, if it is come to the guideline of state government, 1:3 for one post for direct recruitment. That is also, I have 178, page 178. Page 178. For recruitment through interview oblique viva voce, the number of the candidate to be admitted for interview viva voce will be 3 times in advertised post vacancies as decided by the Commission or as per the Government of Arunachal Pradesh, Department of Administrative Reform, notification such and such. In the advertisement itself, they said that they will follow the government guideline. As per the government guideline, one post for 1:3. How they call the 14?
How
And
they call? 14.
14 for the same post. On what basis? This is the clear-cut violations of the norms of advertisement made in their own condition.
Advertisement is at page number 41.
Page advertisement in the 38.
38.
And the rules and guidance have been made in the 41. Neither they have
In
adopted
advertisement, where it is mentioned?
page 41. Oh, page 41. Come again, 42. 42 para 9. Come to the para 9. Application received in response to the advertisement for the above mentioned post will be scrutinized and shortlisted candidate only will be called for interview. Only it should be shortlisted. Mere fulfillment of minimum eligibility criteria laid down in the advertisement does not entitle automatically a candidate to be called for interview. Now, another example, one thing I'll show you. Come to the page 224.
No. You show me the provision where against one post, only 3 candidates are to be called.
178, my lord.
178,
page number 178.
178.
Yes. Conduct of interview oblique viva voce.
Your
170.
It is afraid, my lord, it is a guideline for the Arunachal Pradesh Public Service Commission. It might not be applicable for Arunachal Pradesh University, which is a statutory body, my lord. This is my humble opinion, my lord.
Not humble opinion. You go through the advertisement. You go through the advertisement.
This is in
Yes, 170.
178, my lord.
78.
Page 178.
It is in line with Department of Administrative Reforms. Administrative reform का notification pursuant to it.
This is the
That's
notification.
the advertised post though. What was the number of the post?
Number was number 1.
1. So only 3 candidates also have been called.
Yes. As per the state government guideline. Because in the advertisement itself they said it.
Where, in which column of the advertisement they have stated it?
Yes.
It's clause 9.
No. Yeah. Page 41.
Page 41 clause.
And point number 2. The criteria for shortlisting and evaluation will be guided as per the established UGC and state government guideline. Hello.
API is mandatory, right?
And again,
Now show me the state government guideline.
Page 178.
State government guideline.
government guideline is 1:3 ratio.
178, my lord. Page number 178. 178, my lord.
This is a state government guideline.
Yes. Yeah, the advertisement they have quoted it.
Okay. And what is the UGC guideline?
UGC guideline is they should adopt API.
Where it is provided?
Okay, nine. She
62.
62. Selection procedure.
Yes.
Yes. The overall selection procedure shall incorporate transparent, objective, and credible methodology of analysis of merit and credential of the applicant based on the weightage given to the performance of the candidate in different relevant parameter and his her performance on a grading system performed based on appendix 2 table 1 2 3 a 3 b 4 and 5.
Table.
And now this which we have shown here, table 1 2 3 a 3 b 4 and 5. That table has been shown in page 1092.
Page number?
92.
Yes.
Now, here, table number 3A, criteria for shortlisting of the candidate for interview for the post of assistant professor in universities.
This is the table.
Now, these are the criteria. Post-graduation marks, graduation marks, in the graduation marks, person who secured 80%, he will get 15 marks, and postgraduate, he will get 25 marks, and MPhil, PhD, NET with JRF.
224.
Now,
224.
Now, come to
224.
Now come to the 224. Page 224. The petition. Yes. The petitioner's name is in serial number 11.
80.5.
These are the candidates call for interview.
She as per the API, her mark is 80.5. Because she is having PhD, she is having service experience, he is having so many publications. Whereas the president whom I have challenged, response number 6 is serial number 14. She is nearly PhD.
No publications.
No publication. No slate or and secure only as per API. She secure only 46.8. This is as per the API. Now, if it is adopted, then the person who secured 46% as per API rate, he will not qualify. After I am the topper, after me, there is person who secured 69, who secured 62. So, and one secured 63. Now, as per the API. So, when
another person is there, another candidate is there, his total marks is 81. Yours is 80.5.
Yes. Yes.
My lord, top 3 candidate has to be called.
A top 3 candidate has to be called.
Okay.
So why he should be called?
This, where is that API rules?
API rules?
Yes.
API rules. Now, page 62, selection procedure, the 6.0. Here I have read out that the university shall adopt this regulation for selection committees and selection procedure through their respective statutory bodies, incorporating Appendix 2. Appendix 2 I have shown. Appendix 2, Table 1, Table 2, Table 3A, 3B, 4, and at the institutional level for the university department and their constituent college, affiliated college, government college, aided autonomous private college to be followed transparently in all the selection process. The universities may devise their own self-assessment performance appraisal from form for teachers in strict adherence to the Appendix 2, Table 1, Table 2, Table 3A, 3B, 4, and 5 specified in this regulation. So, those tabulations are only to shortlisted the candidate. Now, come to page 47. Yes.
Page number?
47.
47. The academic score as specified in Appendix 2, Table 3A for universities and Appendix 2, Table 3B for college shall be considered for shortlisting. Shortlisting API means for purpose of shortlisting of the candidate for interview only. and selection shall be based only on the performance in the interview. So in the performance, the interview result will be declared as per the performance of the candidate, but after shortlisting the candidate. Whereas they have not made any shortlisted candidate. They have called 14 candidates for one post.
Now, you tell me one thing. This page number 168. That is the Manual for Conduct of Examination 2024. It was issued by the Arunachal Pradesh Public Service Commission, Itanagar. Whether it is the government guideline.
Oh, 168.
Yes.
This is for government guideline. This is followed by the Arunachal Pradesh Public Service Commission.
No, maybe Public Service Commission is a statutory body.
Yes.
Their guidelines may not be the guidelines of the government. Do you have any other document or notification to show that this is the guideline of the government also?
My lord, 178. Clause B,
Clause
B, my lord.
Where is that notification?
My lord, this 1:3 ratio has been laid down as per the notification which has been issued by the Department of Administrative
No,
Reform.
that's all right. Where is that notification?
My lord, that notification we could not find, but this is in pursuance to this notification only, my lord. The notification we could not find, but it has been cited, and it's the one which has been used to lay down this ratio, my lord, of 1:3.
Who is appearing for the state respondent? Mr. Jamo,
Yes, madam. I am for the state respondent.
can you produce this notification? It is of a comparatively new notification dated 14th of August 2023. Page number 173.
78.
Oh, sorry, 78. Clause B.
We are standing counsel, my lord, for the department, education department, my lord, higher and technical. We will try to obtain it only from them, my lord.
Okay. So since a reference is there of this notification, then on the basis of this notification, the APSC has formulated this rule. Three times the advertised post. If one post is there, then only 3 candidates has to be called. Why 14 numbers of candidates were called? Where is the shortlisting candidate?
My lord, actually, it is actually a thing after this written test, my lord. It is a thing to be followed after written test, my lord. If there is one post and 3 highest scorers will be shortlisted amongst the written qualifier, my lord. That was the implication of this
Notification.
yes, my lord. But and apart from
No, whether here written test is required.
no, written test is not required, my lord.
Here
part
this
my-
API is provided.
My friend will clear that, my lord. He is the Arunachal Pradesh University. He will clarify that whether written interview is required. But in our colleges, that we are running like the Jawaharlal and all, there is no written test, my lord. That I am sure about. But what about him?
No, this API is provided. Academic performance indicator.
My lord, there should not be written test. Written test होता है.
My lord, minimum is to be 1/3.
1/3.
Yes.
Why 14 candidates
Minimum
were
is
called
3.
here?
Minimum is 3. But the university can call even 200, 300 person also.
No.
And this citation will be placed before this court at the time of hearing.
Pardon?
The citation should be placed before this court at the time of hearing. There is a provision.
There is a provision.
Yes.
You show us
This
the
is,
provision.
1/3 is the minimum. Maximum, there is no limit.
You show us the provision.
Yes. Later on, at the time.
Otherwise, no. Otherwise, we will stay the order. Stay the process.
My lord, in this case, he has participated the interview.
Mm.
After declaration of the result, he has made these allegations.
Yes. What wrong with that?
Oh, I don't like it.
My lord, we're not seeking any stay at this point of time, my lord. We're not seeking any stay, my lord. This notification is, they've already been issued the calling letter also, my lord.
Okay.
They've been issued the calling letter with challenging, and we are saying that we should be appointed in place of them after.
Call letter issued.
Already issued, my lord. September 10 it was issued.
Call letter or appointment letter?
Appointment letter.
Issued.
Yes, my lord.
No, calling letter and
Appointment letter.
appointment letter also issued.
Issued.
Yeah. And result sheet is annexure 6, my lord. Annexure 6.
Page number?
Annexure 6 is page number
133.
133. Annexure 6, this where I am challenging this result. Annexure 6 and annexure 4.
The serial number here?
No. Serial number page 134, serial number 13 is the response number 6 here in the case, and my name is appeared here. Petitioner name is appeared in serial number 9 as waitlist
candidate. You show us the rule.
Lord,
The university.
So,
I have
by
not
this
received
time, my
any
notice
instruction,
may be issued. Notice may be
I have
issued.
not received any instruction.
No, you have submitted that minimum is 3.
Yes.
There is no upper limit.
Yes.
Where it is provided?
That the racer has informed me regarding this matter.
Register has informed you.
Yes.
When this appointment letter was issued?
Appointment letter. Result was
October 10, my lord. It was issued on October 10, but we have not attached any.
When that respondent
the
number.
resolution was made on 30 September 2025. 30 September 2025.
But if appointment was made in the year 2025 in the month of October, there is delay in filing this petition.
No, my lord.
Why?
As per the provisions, the UGC norms, when we feel it agreed, we have to submit our appeal and grievances before the chancellor. So governor is the chancellor. So
You have submitted your application.
yes, no, we appeared, we filed, but see, all the petition which we have filed before they go, His Excellency, governor is the chancellor.
Yes.
He has referred to the, again, universities. So we have to fulfill the section 8 of the UGC law. As per that, the cause of delay was done because of the appeal before the chancellor.
No, whether that appeal was ultimately disposed of.
Ultimately disposed of, then we are coming.
And what is the result?
The result was that actually it is like a stricture. This is almost like a stricture.
To the?
To the vice chancellor.
How?
Actually, our grievance, he was listened, but he has not interfered. Our demand. Our demand was that the result is to be set aside, but it was not done. So we are coming to the court.
He judgment all set aside.
Okay.
We have made an appeal before the chancellor. So that is the root cause.
Let notice go at this instance.
Yes, notice we should.
Heard Mr. M. Partin, learned senior counsel, assisted by Mr.
Mukbang Partin.
Learned counsel for the petitioner, Mr.
ठीक है
Learned counsel for the respondent number
1, 4 and 5.
1, 4, and 5. Mr. Zamo for respondent number
2 and 3,
2 and 3. In this petition under Article 226 of the Constitution of India, the petitioner, namely, Dr. Tadu Rimi has challenged notification number APU/ADBT/2023/5278 of /11 dated 9/8/2025, by which the Arunachal Pradesh University Pasighat, issued by the Arunachal Pradesh University Pasighat, and also the notification of result memo number APU F.NO.APU/2023/5520/8 dated Pasighat 30th 9/2025, and also for issuing direction, also provide for issuing direction to the respondent authorities for appointing the petitioner to the post of assistant professor in the Department of Social Work. Mr. Partin, learned counsel for the petitioner, submits that the Arunachal University has issued one advertisement dated 17 July 2025 for filling up of one post of assistant professor in the Department of
Social Work.
Department of Social Work. And the petitioner has participated in the said process, and her receive notice. However, the requisite copy of the petition be furnished to them during the course of the day.
My lord,
It's a matter of-
we have a prayer to make, my lord. With respect to respondent number 6, who is a private party, we don't know her address, my lord. So therefore, we have mentioned her address as APU, my lord, because she's an employee of that university now. So we can issue notice to that. We'll send a letter. We'll send a post to that address, my lord.
Okay. Okay.
That leave may be granted, my lord. That
The learned counsel for the petitioner also submits that the respondent number 6 is presently the employee of the respondent number 1. Respondent number 1. And as such, they may be permitted, the petitioner may be permitted to effect service of notice through the respondent number 1. Respondent number 1. Fair allowed. So we'll resume after 5 minutes.
Item number 5.
May it please your lordship.
Yes.
May it please your lordship. Lordship, I beg to appear for the petitioner. My lord, in this case, this is a tender matter. My lord, the NIT was issued on 20th of March 2026. And if my lord comes to page 21 of the petition.
Yes.
My lord, this is the NIT, my lord. Executive Engineer, PWD, Arunachal Pradesh, Tawang Division, invites sealed itinerary tenders from PWS on behalf of the Governor of Arunachal Pradesh in exercise of power conferred under Section 5 of Arunachal Pradesh District-Based Entrepreneurs and Professionals Incentive Development and Promotional Rules. My lord, this should be Act 2018. From all registered contractors, my lord, this is important, in Class 4 and Class 3 categories, domiciled within the territorial jurisdiction of Assembly constituency eligible for competitive bidding for the following work up to 11 a.m. on 25/03/2026, and the same will be opened on at 11:30 a.m. on 25/03/2026. Now, my lord may come to the next page, my lord. What I am concerned with is serial number 10. On the next page, my lord. We are interested in this tender, NIT number so-and-so. The work is construction of multi-purpose G+2 building for Market Committee of Old Market, Tawang. And Lordship will see the estimated cost put to tender, 4,68,31,000. Now, why this is important, I'll come to it in just a bit. My lord, after that, if my lord comes to the next page, page 23.
Yes.
Tenders will be open on the same day at 11:30, just below the table, my lord. Tenders will be open at 11:30 a.m. So-and-so. Thereafter, Lordship will come to the criteria, the bold portion, criteria for eligibility of issue of tender documents. Now, Lordship may come to serial number 1. It should be renumbered 2, but the second serial number 1. Lordship finds it, my lord. The second serial number 1.
Yes.
Sale of tenders shall start from 10 a.m. of 21/03/2026. The date is also important, my lord. And the last date of receipt of application for issue of forms shall be stopped 1600 hours, 2 days before the date of tender opening, inclusive of holidays. Last serial number 2. Last date of issue of tender forms will be stopped 2 days before tender opening. Now, my lord, this tender was issued on 20th of March 2023, which is a Friday. 21st of March, Lordship knows, was Eid and a Saturday, which is holiday. 22nd was also a holiday on account of being a Sunday. The tenders are to be opened on 25th. And as per the second serial number 1, the sale of tender forms will be stopped from 1600 hours, that is 4 p.m., 2 days prior to the date of opening of tenders, that is on 23rd, which is Monday. That is only 1 day which is given, my lord, for sale of tender forms. And this was issued on a Friday. Next day, Eid, and thereafter holiday. And the last date of submission is today. Now, this is one part. This other part, my lord, is since lordship is here on the writ petition itself, there is an additional affidavit file. I have brought on record certain tender conditions which need examination. But since lordship is on the writ petition itself, lordship may come to the Arunachal Pradesh District-Based Entrepreneurs Act from page 25. Annexure 3, my lord. This is, lordship may read section 3 at page 25. Preference to district-based entrepreneurs and professionals. The state government shall, in its development and welfare-oriented projects in a district, give preference to the district-based entrepreneurs and professionals to secure equitable distribution of state developmental works amongst different categories of entrepreneurs in project works up to or involving the amounts as prescribed in the schedule here. Now, this schedule, lordship, is on the next page. Lordship may next. Lordship may directly come to serial number 5 in the schedule. Above 3 crore and up to 8 crore. What is the eligibility as per this act, my lord? All registered contractors in class 2 categories domiciled within the territorial jurisdiction of the assembly constituency. Lordship had read the NIT. The NIT, my lord, the tenders are invited, the bids are invited only from class 3 and class 4. But the act says for works above 3 crores and up to 8 crores, it is only class 2 who are eligible. Now, lordship may once again, if lordship comes back to the NIT at page 22, we are at serial number 10 of the work, my lord. This is 4 crore 86 lakh. Page 22, my lord, serial number 10. This is 4 crore 86 lakh. So the eligibility is only class 2 contractors, not class 3 and class 4, which is mentioned in the NIT. For this NIT is dehors the provisions of the Act. And very surprisingly, the Act mentions, it mentions about section 5, of the rules. There cannot be section in the rules. It obviously refers to the Act. And in any case, it refers to the 2018 rules. But rules cannot be dehors the Act. This entire NIT, my lord, is dehors the Act. And further, the timeline, lordship has seen only 1 day given for sale of tender documents. Now, if my lord takes up the additional affidavit,
Mr. Nayar,
my lord,
whether this Saturday and Sunday,
my lord,
no tender document was issued.
My lord, offices were closed, my lord. Saturday was Eid, my lord. Sunday is a holiday, my lord. Offices are not there. The offices they do not function, my lord. And there is another aspect, my lord. One additional affidavit has been filed today. They have brought on record or tried to bring on record, my lord, the tender terms and conditions. They were skipped out, my lord, in the main writ petition. In the additional affidavit filed today, the special terms and conditions of the contract. If my lord comes to, if my lord takes up the additional affidavit, my lord has found it.
Yes.
My lord may come to Annexure 5 of this is from page 33 in the additional affidavit. These are the special terms and conditions. My lord, since we could not obtain the entire SBD and the documents were not very legible, we could not annex the entire document, but we have extracted the special terms and conditions. It starts from page 33. The relevant is serial number 42, my lord, at page 37, my lord.
Yes.
My lord, serial number 42 or condition number 42. Before participating in the tender, intending bidder must visit the site and obtain certificate of such visit from the site engineer and should submit it along with the tender. My lord, only 1 day given for the sale of tender documents. I have to, my lord, participate in the bid, my lord, within 25th, and within 1 day, I have to visit the site, obtain the certificate from the site engineer who may or may not be available in the site, and my lord, thereafter analyze what my bid should be, get the prices, and submit the bid on the very next day. This is what is the purport of this entire NIT. It is very apparent, my lord, it's my humble submission, it's very apparent that this NIT is tailor-made to suit certain persons. And my lord, this is very restrictive in the sense an adequate opportunity and fair opportunity is not being given, my lord. This is a restrictive tender. And they, my lord, call it from only class 3 and class 4, whereas the eligibility is only of class 2, not of class 3 and class 4. My lord, in my humble submission, my lord, this NIT needs to be interfered with. It should not be processed, my lord. This is tailor-made, my lord, intended to favor certain blue-eyed boys who are already aware of this, of the process. They have everything ready, they'll submit it. My lord, it's humanly impossible, my lord. 1 day for sale and 1 day for visit, my lord.
Yes, Mr. Ratan.
First point. My lord has seen 1 day time has been given. So my lord will see page
That is on-
23.
that is Friday.
Friday.
Only the Friday.
Yes, what it says and at page 23.
Mm.
Criteria of eligibility for issue of tender documents. Criteria are given. Then there are two serial number ones. The second one, my lord, sale of tender shall start from 10 a.m. of 21/3/2026 and the last date of receipt of application. My lord will kindly note, application for issue of forms shall be stored 16 hours, 2 days before the date of tender opening, inclusive of holidays. Inclusive of holidays also is given, my lord. The last date of issue of tender form will...
No. Is it your case that on Saturday,
Yes,
and
my
on
lord.
Sunday, the office was open?
Yes, I'm coming to that. That's why they have to first file a application along with their original, showing their original registered documents, registration certificates, my lord, at serial number 3, my lord. Original registration enlistment documents shall have to be produced for obtaining tender forms. That also is a requirement. Failing which, tender forms shall not be issued. Then production of Xerox attested scanned copies of original documents for obtaining tender forms will not be entertained. Up to date certificate of registration of GST. This, my lord, I'm talking about original registration. These are required while you seek for tender documents. And my lord has seen in their representation at page 28. They have not said that we are applying for tender forms. On 21 itself, they have filed this. It has been received by the office. The receipt also is at page 29 in the bottom left hand. They have not filed any application that our original registration certificate, enlistment certificate is here. You issue us the tender forms. Nothing is there. In this entire representation, they are only seeking time that to extend the tender process. It is not sufficient. They are only seeking this. They have not said that I'm class 2, I'm eligible for this particular work at serial number 10. They have not even said that. Now in their additional affidavit, they brings up terms and conditions of the tender. They have themselves not obtained any tender documents. My lord has seen it is insufficient. But in their additional affidavit, they are bringing terms and conditions of the tender, meaning thereby the other bidders, they have applied and from that they have obtained these terms and conditions. Otherwise, in their representation also, they have not sought for any form or any application to furnish the tender documents, tender forms, to fill up the tender form. They have not obtained the tender documents. to fill it up also. My lord, if,
No, their contention is that the time, 1 day is not sufficient and
No, my lord,
Saturday, Sunday is holiday.
that is only for obtaining the tender. Even on 21st, they could have obtained the tender documents. To fill up, it is up to 25th of March, today, up to today at 11 o'clock, it was the last day. It is not 1 day they have been given. They could have obtained it on 21st and fill it out on 11 o'clock today.
Today is the scheduled date for opening the tender.
No, to deposit the tender, and after depositing the tender, it will be opened today itself.
Okay.
It was to only to procure the tender document that last date was given. Procurement of the tender documents. After procurement,
So
you had
that is till today.
Today, my lord will kindly see. It has in the at page 21 in the NIT itself, up to 11 a.m. on 25/3/2026, and same will be open on 11:30 a.m. on 25/3/2026. In the last line, my lord, and even in the terms and conditions, tender obtaining and tender depositing date. It is that you have to file an application that you issue me a tender document.
No. Why sufficient time has not been provided?
Sufficient if we count it from 25 till today, 21 to till 25. It is 5 days, my lord. Sufficient time. If they obtain it on 20, on the last date on 23rd, it is up to them. They will have only 2 days. If they obtain it on 21st, they had 5 days. And it is item rate only, my lord. So they have, in fact, not even on 21st, they could have at least applied for the tender documents. They have not applied. They have not said that issue me tender documents in their representation.
But they have filed on representation for extension of time.
Only extensions of time. They are seeking extension of time. They have not applied also. Applied even the tender documents to issue tender documents so that they can fill up.
No, had it been extended, then they would have applied for the tender document.
Had they obtained the tender document and said that it is not enough, we are not having enough time to fill it up, you extend it, that would have been a different thing. They are simply saying that you extend the tender.
They have not participated in.
Not participate, not even
not obtained the tender.
Yes, not even obtained. Had they obtained and said that no, these are voluminous and we want some more time, so extend the date of depositing the tender. That would have been this is only for procurement of the tender documents. That also they could not do. If on 21st itself they could write a representation for extension, why couldn't they obtain the tender documents? That is my first submission.
And what about this violation of the act?
The violation of the act, to this, I will have to obtain instruction that as per their documents annex, the amount is 4 crores something. At serial number, that particular work, serial number 10, it's 4 crores 68 lakhs. And as per the rules, class 2 contractors are eligible to bid for 3 crores up to 8 crores, meaning thereby it has to be, the class 2 contractor has to be invited. For that, I'll have to take instruction, my lord, whether this is of 2022, whether there has been any enhancement in this bid.
In the meantime.
Yes, my lord. Because I believe that above 5 crore to 8 crores. It has, class 2 has been above 5 crore to 8 crores. Earlier it was 3 crores to 8 crores. Now class 2 is, I will have to take that proper instruction, but I believe it is now from 5 crores to 8 crores.
Yes, Mr.
My lord.
Nayar.
My lord, insofar as this is concerned about the enhancement of the limit, my lord, it is an act, and act cannot be unilaterally revised by way of an office memorandum. There has to be an amendment of the act. The schedule is there in the act.
Yes.
So simply an office memorandum will not do. It has to be an amendment of the act,
Yes,
and
my
there is
lord.
no amendment.
Yes. That I will take instruction, my lord.
My lord, it is my
Because,
specific instruction that there is no amendment of the act. This is the last one. And the other aspects which my learned friend, the additional AG, has pointed out is about the submission of this representation on 21st. My lord, we prepared this on 21st itself, but the office was closed. This was received on 23rd. They have not put the date of receipt. It was received on 23rd. And about obtaining, it was received on Monday. About procuring the documents, my lord, the entire thing is unworkable. Why the hurry? And this is not a small work of construction of only a room. The lordship will see the estimated cost, 4 crore 68 lakh and 31,000. That shows, and it is construction of a G+2 building. If it is a building, can everything be done at a super fast speed in one day, my lord? And assuming we obtained the document on Monday, 23rd, only one day left, and my learned friend, the additional AG, is incorrect about 5 days, taking it from 21st. Submission is on 25th. So 4 days. Between the 4 days, that is Monday and Tuesday. Monday for obtaining the documents, Tuesday for site visit, obtaining the site visit certificate from the engineer who may or may not be there, and thereafter preparing the estimate, analyzing what is required, what is not to be required, and submit the bid on the very next day. Is this possible, my lord? The very issuance of this NIT with the timeline, as well as the violation of the act, reeks of, my lord, something else of extraneous consideration. I humbly implore lordship that this NIT needs to be interfered with. It's very clear, apparent, my lord, from the face of it. My lord, the AG has pointed about procuring only one day. Can the AG say that the officers were there on Eid, the holiday, and Sunday? My lord knows how government offices function. It is not possible, my lord. And my lord,
in their additional affidavit, others have procured.
How
And
many
that's
others?
why
And who, my lord?
Others have procured. That's why the terms and condition of the tender is also, they have annexed.
My lord, is this tender term and condition?
If no one could,
my lord, is the tender term and condition
let me
an
take
official
instruction.
secret?
My lord, let me take instructions.
My
The
lord,
first condition is that they should at least have procured the tender documents,
my lord,
which they have not done.
My lord, is the submission that the tender terms and conditions someone has obtained, and therefore it has been obtained by everyone, the tender terms and conditions can be violated? And my lord, is it an official secret that I cannot do it? I cannot obtain. I can take a photocopy from someone. And why have they not uploaded the tender terms and conditions on the website? What stopped them, my lord, from allowing the bidders to download the tender terms and conditions? And the other things which the learned additional AG has pointed out about production of the original documents we have all the documents, we can produce. But for purchasing the tender documents, why are they required, my lord? This shows certain other things, my lord, which clearly indicates, my lord, first, violation of the act. Second, my lord, is the timeline from which it is apparent, my lord, that it is not workable for others if they do not have prior notice of this. It is very much apparent. 1 day plus 1 day. 23rd is 1 day, 24th for going to the site.
Let there be a stay of the tender. You say prima facie this act is violated.
No, my lord, here.
Timeline is very short.
My lord, I don't have that, this amended, this, what they have annexed, the capacity to bid, my lord, that, what act, in this, they are harping on that 3 crores to up to 8 crores, my lord. In fact, this, to my knowledge, my lord, this has been further amended.
No, whether the act was amended.
Yes, my lord. Act was amended, and act was amended because what I that in
Okay,
serial number one,
let us
up to 50 crores was without tender work order system. That was amended, and subsequently, I believe, which I cannot say right now, from 5 crores to for class 2 bidders, it's not 3 crores to 8 crores, it's 5 crores to 8 crores. That I'll just let it be taken up in the afternoon, my lord.
Yes, at 2 o'clock.
Yes,
Yes.
at least to
Mr.
this.
Nair at 2 o'clock.
My lord,
Let him obtain instruction.
My lord. Deeply obliged.
Next item.
Item number 6.
Same.
Same. Okay.
6 and
Same
7.
here.
7 is also same.
Same here.
Seven
My
is
lord, 6 and 7 same.
Okay.
Same.
Okay.
6 and 7. But
Okay.
Item number 8.
My lord. Deeply obliged.
Wait, please, Your Lordship.
Yes.
Your Lordship, here the petitioner is challenging the impugn appointment order dated 23/2025, by which the private respondent number 9 has been appointed as junior engineer in the Department of Power under 5% meritorious sports person quota, Your Lordship. The impugn order is at page 70, Your Lordship. Annexure number 4. Your Lordship, on 12/6/2020, an advertisement was issued, Your Lordship, by the Power Department through the superintending engineer. That is the respondent number 4. In prescribed form for filing up 2 temporary Group B non-gazetted technical posts for the post of junior engineers, electrical under 5% meritorious sports person quota. After that, Your Lordship, the petitioner, being a meritorious sports person from karate discipline, Your Lordship, and having the degree of Bachelor of Engineering in Electrical, he applied for the post in pursuance to the advertisement. However, Your Lordship, here, during the pendency of the selection process, an FIR was lodged by one Sri Kipa Kaha. That is the General Secretary of Arunachal Taekwondo Association, Your Lordship, alleging that certain candidates are using forged documents, Your Lordship, forged certificates, by which they are applying for the post under sports quota in various departments. After that, the selection process was halted for almost 4 years. And interestingly, Your Lordship, during the investigation, the private respondent number 9, who has been appointed, Your Lordship, was found to be using, who was found to have used forged documents, Your Lordship. That is by in his form number 1, the signature of one Ambedkar Gupta, Your Lordship, it was scanned signature, Your Lordship, due to which charge sheet was filed against him. And initially, Your Lordship will find here, out of the 2 advertised posts, Your Lordship, earlier 2 candidates were selected and appointed. There is one Sri Rilum Rigong from the archery discipline and one Duvam Parame from Interim discipline, sports discipline, Your Lordship. And the humble petitioner has no dispute in this regard, Your Lordship, since the appointment was purely made on the achievements in the respective sport discipline. Now, the grievance of the petitioner starts, Your Lordship, when out of these 2 selected posts, one Sri Duvam Parme, who was appointed from sports discipline of Kerom, he did not accept the appointment, Your Lordship. Hence, one post remained vacant. And if that remaining post has to be appointed from the remaining candidates, Your Lordship, it is the humble petitioner, Your Lordship, against whom nothing was found during the investigation. He was clean. However, in this post, Your Lordship, the private respondent number 9, against whom charge sheet was filed, has been appointed, Your Lordship. That is the grievance of the petitioner. Because, Your Lordship, earlier there were 34 candidates, Your Lordship. And out of 34, 12 candidates were shortlisted. And the petitioner was one of the shortlisted candidates. And no doubt the private respondent 9 was also shortlisted. However, during the pendency of the investigation, it was clearly found that the private respondent number 9 has used forged documents and submitted forged documents in his form. So, Your Lordship, at this stage, Your Lordship, my humble submission is to issue notice, Your Lordship, and call for the records. Because
who has conducted the selection process?
Under the chairmanship of respondent number 4, that is the superintending engineer, Department of Power.
Okay.
And
Lordship, I'm appearing on behalf of El Parme, Standing Counsel for Power Department.
Yes.
The notice may be issued, Lordship. We'll take instruction.
Okay. Heard, Mr.
D. Tata, Your Lordship.
Learned Counsel for the petitioner and Mr.
Yes, Your Lordship, on behalf of El
Counsel
Parme.
appearing on behalf of Mr. El Parme, Learned Standing Counsel for the Power Department, being respondent number.
Respondent number 1, 3, 4, 5.
1, 3, 4, 5, and
6, Lordship.
6. And Madam Ifa?
2 and 7.
2 and 7. This Under Secretary, Department of Arts?
Yes, it's 7. You know.
8. 8.
Yes, Lordship.
8. 7 and 8.
Yes.
In this petition under Article 226 of the Constitution of India, the petitioner has challenged the result notification dated 30/3/2025 issued by the superintending engineer within E, AP Electrical Circle 1, Quad, CWRD, Naharlagun. What does it mean, this quad?
Coordination, Your Lordship. Coordination, yes.
Selecting the private respondent number 9 as junior engineer. Within bracket electrical group B, non-gazetted under meritorious sport person quota in the Department of Power, and also the appointment order dated 20th March 2025 issued by the superintending engineer within bracket E, AP Electrical Circle Court, Naharlagun, appointing the private respondent number 9 as junior engineer. Group B, non-gazetted under meritorious sports persons, MPS quota in the Department of Power, Kaptop, Arunachal Pradesh. The learned counsel for the petitioner submits that the petitioner has participated in the selection process for filling up 2 posts of junior engineers in the Power Department under meritorious sports quota.
Yes, Your Lordship.
Sports person's quota, and the advertisement was published on 12/6/2020. Annexure 1 is the advertisement.
Yes, Your Lordship. 12/6/2020.
And the petitioner has also participated in the said selection process, and altogether 34 candidates have applied for the same, and out of the 34 candidates, 12 candidates have been shortlisted, and the petitioner and the private respondent number 9 are also there in the list of 12 candidates. Then thereafter, 2 persons were selected selected for the aforementioned post, and one person has not joined, and in the said post, the petitioner ought to have been appointed, but instead of the petitioner, the respondent authorities have appointed the private respondent number 9, against whom one complaint was instituted by who lodged the complaint?
One Sri Kipaka,
Kipaka,
the secretary of
for enclosing forged document with the form, application form.
No, Your Honor, that FIR was lodged against various candidates. It was found that various candidates are using false certificates.
FIR for
Not against any individual.
for using false certificate by some of the candidates. And after investigation, police submitted search sheet against the respondent number 9 also.
Yes,
private
sir.
respondent
For
number
supplementary
9
charge
also.
sheet.
And in spite of search sheet being submitted against the respondent number 5, the respondent authorities have appointed him. And being agreed, the petitioner approached this court by filing the present petition. The learned counsel appearing on behalf of Mr. L. Parnell, learned conducting counsel for the petitioner, has rightfully issuing notice. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process upon respondent number 9.
Yes, Your Lordship. Private respondent number 9.
Respondent number 9. However, no formal notice is required to be issued to the rest of the respondents since their standing counsel entered appearance and received notice. However, as the requisite copy of the petition be furnished to them during the course of the day. Please the matter after 4 weeks.
Deeply obliged.
Deeply obliged.
Item number 9.
In the earlier occasion, the central government standing council said that he will go through. Even in the morning, he informed me that he will have to take instruction. Yes, he is here.
As per the documents produced by the counsel for the petitioner on the last occasion, I've gone through this provision, for these documents, even instruction is not required, It's because it is very much clear, The documents which has been relied by the colleague of office memorandum dated 1st September, 1990, And firstly, he has made submission that these documents will cover his case.
But it appears that this is in respect of civilian employees.
That I wanted to point out. This is for civilian, exactly, And the civilian, during this the untoward incident happened, It is in respect of civilian,
employees. Okay. It
And-
is not civilian employee.
Civilian employees.
Okay.
And another,
Now-
Army person.
last person, para 9. Para 9 is also in respect of the honor before, even if civilian, this will be applicable to honor before the 1st August 1997.
Okay.
And before that, if there was any rules, orders, or instruction in force, that will be government, not retrospective.
Retrospective.
Okay.
First of all, this
No,
document is not applicable.
okay, that's all right. Agreed that this OM will not help him. But you see, there is a decision of Supreme Court in this Union of India and others.
Kanchan, Dua,
Radhika Devi.
Yes.
Radhika Devi versus Union of India and others. Here, the Supreme Court has granted, no, High Court has granted ex-gratia of 5 lakhs as compensation
comes.
And Supreme Court has upheld the same.
I'm sorry, madam, that judgment I have not gone through.
You have not
How-
gone through.
Yes, madam. However, madam,
You see, this paragraph number 17.
madam, in view of the date of death, due to cardiac arrest, madam, the
Not
appellant,
entitled to liberalize family pension. Insofar as the payment of ex-gratia amount compensation is concerned, we are convinced that the appellant is entitled to 5 lakhs as ex-gratia compensation in accordance with the instruction dated 22/9/1998.
madam, this is in respect of 1998.
Yes. Yes.
Madam, this madam, incident happened in the year 1994, madam.
94.
Petitioners.
Petition, madam. I don't know, madam, whether it is this instruction, madam. We have not gone through, madam. It will cover or not, madam. I'm sorry, madam. I have not checked out. And and the special benefit, madam, to that extent, madam, my submission is, madam, he has already been given, madam, the ex-gratia, madam. Payment has also been made, madam, by the army authorities, madam.
Ex-gratia.
Ex-gratia, madam. The compensation amount we have already paid, madam.
What is the amount?
Amount is
When it is paid.
$150, madam. Of course, madam.
This is my due because it is my insurance. 1,50,000. This is not ex-gratia. Group insurance. It was my during service time, my husband's group insurance.
Then, madam, in that case, madam, that notification has to be, madam, again.
Yes. According to the instruction dated 22nd of September 1998.
Madam.
So can you obtain that instruction today?
Madam, that instruction is given or not, madam. Yes, madam. 22 September 1998. The special benefits that were granted by the government of India for ex-gratia payment is payable in all cases of the death and disability in service to the family members of the armed forces personnel who died in harness. It's as the case as the death of the appellant's husband was not during enemy action in international war or the border skirmishes and action against the militants, terrorists, extremists. The appellant is not entitled to 7.5 lakhs as claimed by her, madam. Appellant is not entitled, madam.
Not 7.5, but you this.
We set aside the High Court orders declaring the appellant is entitled for the liberalized family pension. Madam, it is also family pension, madam, not ex-gratia, madam. She is entitled only for the special army, special family pension only, madam. Further, we uphold the judgments of the Honorable the High Court that the appellant is entitled for ex-gratia payment of Rs 5 lakhs. With the above observations, the appeals are disposed of accordingly, madam. The extent, even if we, madam, for a moment, madam, if consider this to be, madam, the correct, then, madam, entitlement is up to only 5 lakhs, madam, as per this.
Yes, you paid the 5 lakhs.
And my lord, by instruction, my lord, as already informed by the Council for the State, they are ready to pay, my lord, the 2 lakhs, my lord.
No, if she is entitled to 5 lakhs, so why she should accept 2 lakhs?
My lord. So therefore, my lord, we have not seen the, my lord, the notification instruction dated 22nd September 1998, my lord. What is there, my lord, at this stage, my lord, I'm sorry to say, my lord, we haven't, my lord, gone through that notification.
Okay, then in that case, we will list the matter tomorrow.
My lord,
You
I'll try
obtain
to.
instruction.
Maybe, my lord, he has, my lord, I have not gone through. Maybe that notification is given in the, my lord, petition copy, my lord.
Is it with you?
That document is
Your Lordship, 64, I think. Page 64, Your Lordship, of the additional affidavit.
Additional affidavit, in my additional affidavit.
It is there.
22nd September.
Page 68.
I can only. September 1998. Yeah. That is.
Yes,
Yes, page 64. Yes, madam. It's a copy, madam. Bharat Sarkar, Australia, Mantralaya, Ministry of.
But we have that not part of the record. Page number 68.
64.
4, Your Lordship.
64.
Extract. Additional affidavit filed by the petitioner, madam. It seems to be filed on, madam, the 16 May.
No, in the additional affidavit, last page is 60.
Well,
that means, madam, that they have not, maybe they might not have enclosed the.
this is why it is with me.
Okay. Yeah, last page is 60.
In ours, Your Lordship, last page is 71.
Madam, it is September 22nd September 1998, madam.
Yeah.
And madam, special benefit subject, madam, in case of death and disability in service, payment of ex-gratia lump sum compensations to families of defense service personnel who die in her days. Recommendations of the 5th Central Pay Commission. I'm directed to refer to the Government of India, the Ministry of Personnel, the Public Grievances and Pension, the Department of Pension and Pensioners Welfare, OM number so and so, that is so and so, and state that the President is pleased to decide the families of defense service personnel who die in her days in the performance of their bona fide official duties shall be paid the following ex-gratia lump sum compensation. A, B, and C manner. The petitioner case, which is in C. Petitioner case comes under the C. Death occurring during enemy actions in international war or the border and skirmishes and action against women. It seems
The whole notification is not there.
last please.
And how the husband of the petitioner died?
The husband of the petitioner died while he was confronting the Punjab militants at Amritsar district.
Certificate to that effect?
certificate to that effect. It is with my
My lord, page number 7, my
claim
lord.
petition.
Page number 7.
With
No, is
Wait.
there any document to substantiate the same?
Document, my lord, death certificate is I think given, my lord.
Page number 25 is a death certificate. Your Lordship.
Page number
25.
25.
Even the central government recognized me. Recently, the central government has celebrated,
Medical
inaugurated.
Page number 25 is the my lord, death certificate.
Hmm.
Found dead and gun shot.
Gun shot by terrorists.
Even he was awarded Shaurya Chakra.
He was a Surya Chakra winner, my lord, by the
Page number
President of India.
I don't know, second page is not available, my lord. What kind of direction was given in the second page, my lord? Even page number 64, second page is not available, my lord. It is not, it seems, it is not, my lord, the complete document, my lord. Whether applicability, my lord, to that extent is not given. What's here? It's the second page.
I mean, they
Yeah.
my lord, same. So he's come.
There must be second or third pages, my lord.
So his case may come under clause C.
My lord,
Hmm?
if this is the position.
Hmm?
Yes, ma'am.
Action against militant,
Yes, ma'am.
terrorists, extremists, etc.
During Operation Khalistan, my lord, he
Died.
died, ma'am.
He died.
That part we are not denying, ma'am.
This complete document is not available.
My lord.
Mr. Decca, where you got it?
My lord, through website only.
Website.
Yes.
In the website, the second page may also be available.
Yes, obviously it will be available. I will have to charge again.
Okay, then let it be day after tomorrow.
Well, tomorrow I have some preoccupation day after tomorrow and day after tomorrow, my lord.
Then what to do?
Or else, my lord, if-
Oh,
if
without going
produced-
through this, this document will be required for us.
Yes, yes. So I'll bring it with record, my lord.
If you produce it today, then we can consider in the second half.
My lord.
You try.
Today, again, I have another matter. I have another matter.
Next week, my lord, in that case.
Next week, my lord.
Next week.
Yes, my lord.
Okay. Heard Mr. Decca, learned counsel for the petitioner, Mr. Kato, learned Deputy Solicitor General of
So
India.
respondent number 1,
For the
2, 3, my
respondent
lord.
number 1 and
1, 2, 3, my lord.
1, 2, 3. Mr. Riampo,
4 and 5.
respondent number 4 and 5. Person to order dated 17/3/2026, Mr. M. Kato, learned Deputy Solicitor General of India has obtained instruction in respect of the web dated 11 September 1998, and he submits that the said memorandum is not applicable in the case of the petitioner as it relates to payment of ex-gratia lump sum compensation to families of central government civilian employees who died in harness. However, from the decision relied upon by Mr. Decca in Concern Dua versus Union of India and others, and also in the case of Radhika Devi
Yes.
versus
Union of
Union
India.
of India and others in civil appeal number 7525-7526 of 2019 arising out of SLP civil number 8588-8589 of 2014. Especially in view of the observation made in the paragraph number 17 and also in view of the instruction dated 22nd of September 1998 issued by the Government of India, Ministry of Defence, the petitioner is entitled to ex-gratia amount. However, in the instruction dated 22nd of September 1998, the complete instruction has not been produced before this court, and Mr. Deka pressed for listing the matter the next week so as to enable him to place before this court the complete instruction issued by the Ministry of Defence on 22nd of September 1998. Accordingly, it is provided that recessal lists the matter on, let it be fixed on Wednesday, next Wednesday, 1st of April. 1st of April.
Yes, my lord.
Lordship, I would like to mention item number 10 to 21, Your Lordship. I would like to adjourn this matter, Your Lordship, on behalf of Senior Government Advocate Estapin.
On behalf of?
Senior Government Advocate Estapin, Your Lordship. May I please?
For the petitioner?
Yes, Lordship.
Any
Lordship,
objection?
a fixed date may be given.
Fixed date.
Yes.
Suggested date?
6th of April.
26th of April.
6th of April.
6th of April. Okay. Basar, learned government advocate appearing on behalf of Mr. S. Tapin, learned senior government advocate for the respondent with consent from the other side. Press for listing the matter on 6th of April.
Lordship.
Fair allowed. This is a list the matter on 6th of April.
Okay.
Item number 5 to 7.
But I've received the instruction. My lord, in fact, there was an corrigendum already issued. Already for corrigendum, I think including the class 2 contractors also for this particular work. Corrigendum was issued on the same day. Corrigendum on 21/3/2026 itself, saying that the eligibility criteria for participation mentioned in NIT number so and so dated so and so for serial number 10 at page 2 of 4 NIT number so and so the work construction multiple purpose G+2 building for market committee of all market Tawang with estimated cost put up to rupees 4 crores 68 lakhs is for registered contractors in class 2 categories only. This corrigendum was issued. They have not. In fact, they are class 2 contractors. The corrigendum they should they should have obtained the tender papers. They have
My
not
lord,
obtained the.
Yes.
My lord, I have just been informed by my colleague, Mr. Sering, that this corrigendum, he has just got to know, this corrigendum has not been uploaded on the website. It has been posted only on Facebook. Only on Facebook. This has not been uploaded on the website.
It is
Only
in
on
the
Facebook.
notice
How do
board.
we know, my lord? Office notice board. My lord will see the date, 21st of March. My colleague has just shared this with me. It's on Facebook, dated 21st, when the office is closed. This, my lord, it goes on to show the extraneous consideration and the unholy nexus and the work which is in the manner in which they are functioning. On 21st, they issue it on a holiday when Eid is there, my lord. And that too, they don't upload it on the website. How will they upload? The office is not functioning on that day. They post it on Facebook. I am not sure, my lord, Mr. Seding, my colleague assisting me there will know on which date is it uploaded on Facebook. And is Facebook an official medium of communication, my lord? That's what I ask myself, my lord. In any case, my lord, the timelines, everything, it's not workable, my lord. On 23rd, and my colleague has also informed me that we have been able to obtain the document, the tender bidding documents on 23rd, but my lord has seen the site visit condition. On one day, on 24th, I have to go, verify the site, obtain the certificate.
Mr. Ratan, can it be extended by another week?
My lord, they have, today was the last date and it has been,
maybe.
It is already been opened, my lord. Tender is already, when I called up the authorities, it is already, they were in the process of scrutinizing the tender documents. Already it was today up to 11 o'clock, the submission, last date of submission. Timing was till 11. 11:30 onwards, the scrutiny has been started, opening of the tender. And they were in the midst of the tender.
See, you extend the time if possible.
My lord, kindly
Otherwise,
say.
we will interfere with it.
My lord, will kindly say. First contention is that the time limit for procuring the tender documents, the bidding documents were very limited.
That's all right. Why so short time is?
My lord, kindly say, the first contention of the petitioners were that the time for procuring getting the tender bid was very short. Now they say that they have procured. Now they say that for submission it is short again. The time limit they have procured. They have not mentioned it in their petition that they have procured. They have not mentioned in their petition that this corrigendum was issued.
Maybe within such a short time they would not be.
My lord, when others could participate,
all documents and file the documents.
My lord, when others, my submission is, when others can participate, why couldn't they? And let it be subject to the outcome, my lord. Because when others have already participated, how if their tenders have been opened now, financial bid will be open now, and then they will come to know, these bidders will come to know. If it is extended, it will come to know others have participated already. My lord will kindly see, their first submission itself was that it was very short to take the tender document. Now they themselves is saying that, yes, they have taken the tender document. Now they're again saying that it was a short date, very short date. It was still up to date till today. They couldn't submit it till 11 o'clock today. They can file a writ petition, but they cannot submit a tender document there. That is the thing. And then they had said that it was in violation of the act, whereas the corrigendum has been issued. Had this corrigendum instruction not received,
uploaded in the website.
Yes, all notice board.
When?
My lord, on the same date, notice board, and it has been widely circulated, and even I have also checked out, even in the Facebook also, it has been circulated. It is a IPR Tawang. It is circulated.
No, we can check the website now also. It's not uploaded, man.
3 days. 3 days. Even in the I have one this. It has been 3 days all. In the Facebook also, I have also checked out. It has been 3 days. How can this? They have not. Had this instruction not come, they would have simply said that it is in violation of the act and have got the stay. This is suppression of material facts, my lord. Had I not taken the instruction, My instruction, I thought that there is an amendment in the act, but now I have come to know that there is a corrigendum. There was, in fact, there is a suppression of material facts. The stay would have been obtained. On the
My
point
lord,
that
my
it is a
specific
violation
instruction
of...
now, there is no suppression of material fact. I'm sorry to intervene, my lord. There is no suppression of material fact.
Otherwise,
My learned friend has just now
Corrigendum
said
is
it
there.
is not available on the website. My lord may check the website now itself. It is not there in the website. And what suppression of material fact, my lord? They post it on Facebook.
No,
and they do not upload it on the website.
Original tender.
And my lord, the state should be open for fair competition.
Original tender is in the
My lord
website.
has rightly pointed out, very rightly, what
You can check it.
the state if they extend the time, they'll get wider participation. Why don't they want it? This clearly proves
Had the time,
Islamic consideration. And my lord, when they extend the time, there will be wider participation. And financial bid has not been opened. My learned friend's submission is there that they will open the financial bid. It has still not been opened. What harm will come when technical bid is opened, my lord? Technical bid, everyone, it's only the financial bid which would justify, my lord, who is financially responsive. But technical responsiveness, everyone who is technically responsive, my lord.
Okay,
There is
Mr.
no harm.
Nair. Okay.
My lord.
Okay. Mr. Ratan,
Yes, madam.
extend it if not possible for 1 week, for 2-3 days.
My lord,
so
it is
that they
already,
can also
my lord,
participate.
already they have opened the tender, my lord.
Yes. Is there any bar now in accepting the bid of the petitioners?
My lord, they should have submitted their bids today by 11 o'clock.
No, that's all right. But
how possible?
Before
Today by 11 o'clock, they should have submitted.
they also knows that one writ petition is pending in relates to that matter.
No, when my instruction, when I was taking instruction, they were in the midst of the scrutiny of that. By now, they might have finalized.
No, then we will interfere with the same.
Yes, my lord. Yes, my lord.
Then my lord will kindly see. They are
were
on-
served a copy yesterday, my lord. They knew, my lord, the copy was served yesterday.
That if it is possible to extend by 2-3 days, if not possible, we will interfere with it. After 10 or 20 minutes, you will let this court know. Okay, next item.
Yes,
Deeply obliged, my lord.
Item number 23.
Lordship, I have received the instruction.
Yes. The amount has been released?
Yes, Your Lordship.
Released?
Petitioner has received the amount also, Your Lordship.
Okay, then.
Received.
My lord, I have no instructions so far.
Money receipt is there, Your Lordship.
But not. Yes.
Last page, Your Lordship.
Yes.
Yes, my lord.
We can close.
Yeah,
the
can
matter?
close it.
Okay.
Yes, my lord.
Heard Mr. Ismail, learned counsel for the petitioner. Ms. R. Basar, learned standing counsel, learned government advocate for the respondent number 1, 2, 4, and 5.
Lordship. 1, 2, 4, and 5.
Person to order dated 20th/3/2026, Ms. Basar has produced compliance order. Produce compliance report. Compliance report. And she submits that the petitioner has already received the amount and the money receipt is enclosed with the instructions he has received from the executive engineer, Department of Urban Affairs, Rowing Division, Rowing. You have received the instruction copy?
No, I have not received, my lord.
Okay. Mr. Mao, learned counsel for the petitioner, submits that in that view of the matter, this petition may be closed as the prayer being made in this petition has already been complied with. In view of the submission of learned counsel for both the parties, this petition is closed.
Obliged.
the written instruction produced before the court today by Ms. Basar be marked as Annexure A and be tagged to the record. Yes.
Item number 25.
As per your lordship, my lord, I am on DC, my lord. The today matter has come for admission. So affidavit is, my lord, both the sides exchange their affidavit. And so lordship may, my lord, admit the matter and fix a date for hearing. Because we have challenged the, my lord, enacted J order, whereby, my lord, our legitimate right was rejected on the plea of financial constraints.
Okay.
So lordship may can admit the matter.
Counsel for the petitioner and Mr. Riam for respondent number
1, 3, and 4, Your Lordship.
1, 3, and 4. You for
Lordship, I am for the respondent number 2, 5, and 6.
2, 5, and 6. 2, 5, and 6. It is submitted at the bar that in this matter the pleadings have been exchanged by the parties. And as such, the matter may be listed for admission here for hearing.
No. Lordship may can
Accordingly,
admit the
it is
matter.
provided. Yes.
Lordship may admit the matter.
I am passing the order. Why you are interfering with?
My lord.
Admit. List the matter for hearing. After,
my lord, in the month of May, Restrictive.
in the month of May. Okay. After 6 weeks then.
My lord.
After 6.
I'm sorry, my lord. I'm sorry.
Item number 28.
Your Lordship, last order. Also, these petitioners were absent. That's why Your Lordship posted it today deliberately. With some observation that necessary orders will be passed, my lord.
Fix another date or we will dispose of this same.
Your Lordship, for my interest, actually, I would like the matter to be dismissed, my lord. And moreover, my lord, Tamsir Ali, full bench judgment stand against this petition. But these boys who are absent seems to be very young. So, my lord, if they are absent, my lord, very young boys, my lord. Even we don't recognize them. Please give them another chance, my lord. We'll get it dismissed, my lord. Tamsir Ali's full bench judge is clearly against it, my lord. Nonetheless, just
okay for another date then.
Okay, my lord. But of course, on that day, if they fail, my lord, we will plead for dismissal, my lord.
Okay. None appears for the petitioner on call. However, Mr. Zamo, learned counsel for the respondent number.
My lord, 2, 3, 4.
2, 3, 4, and 6.
6, my lord.
Present. And Mr. Riam for
1 and 5.
1 and 5 present. Receive shall list the matter after
2 weeks, my lord.
After 2 weeks. Again, and in the event of subsequent non-representation, appropriate order shall follow.
Item number 29.
Lordship, here I need some time to file affidavit.
Pardon?
Affidavit, Lordship.
You have not filed your affidavit.
No, Lordship.
Heard, Mr. Learned counsel for the petition. Ms. R. Basar, learned government advocate appearing for the state respondent submits that she may be granted some time to file counter affidavit. Fair allowed, recess shall list the matter after
3 weeks, Lordship.
2 weeks.
3 weeks.
3 weeks.
Item number 30 and 31.
I am appearing in the matter, my lord. I'm sorry that yesterday my hours, because of AO season, I couldn't appear. Today, my lord, may first either take the contempt application or the IA for disbursement, whichever your lordship wants to hear first out of the two.
Yes, I'll just, yes.
Yes.
May I proceed with the contempt
My lord,
application first or the IA for disbursement first, my lords?
My contempt petition, my lord, that's why I think I should start the case.
Yes.
My lord will kindly see the list of dates I have given the other side. My lord, just read the list of dates. Then I'll take the contempt. My lord, 38, 2018, lordship got it, my lord. Is a notification issued under section 10 of the Zoom so and so. Your lordship knows the background of this case, my lord. I'll just take to your lordships the contempt, that is contempt 15. 15, no, I mean. Yes. Kindly see that, my lord, the first contempt 15. Lordship got it, my lord? 15. Yes. Please take 15, my lord. And at serial number 10, this is a judgment that has been passed by this court. What does an item judgment do? Page 17, my lord, will kindly see.
Got it.
Yes, lordship got it. Once. Okay. I'm so sorry, page 17. And kindly see few paragraphs I just want to take to this honorable court. 9.2, my lord. 9.2 at page 26, my lord. Kindly see at page 26. So and so, Mr. Tiwari, however, admitted though the land is acquired under section 10 of so and so, yet the compensation can be awarded under the Act of 2013, and the petitioner is not aggrieved on the said mode. And in view of a division bench of this court in writ appeal number so and so, but the petitioner in so and so, but the petitioner is aggrieved in awarding 25% on net present value of the awarded amount as per the State Rehabilitation Resettlement Policy 2008. So my lord will just recollect, there were three modes which they argued. One is there was no objection over assessment of compensation on LARA Act. Number two, our contention is that it is State Rehabilitation Resettlement Policy is applicable. So the project affected families under the policy is that you have to make another accommodation for them. And they have identified the land of these 41 affected families. Only their grievances is that you are not entitled to get 25% of net present value. Because this is not applicable to you. This is only applicable to community land or a clan, because you are a private landholders. So this is not applicable to you. On this contention, Mr. Tiwari has argued the matter. 9.3, kindly see. It is further submission of Mr. Tiwari that petitioner NHPC in WPC 242 is ready. Now please mark this. Is ready to pay compensation to the respondent number 3 to 11 as per the entitlement under the LARA Act 2013, and therefore Mr. Tiwari has contended that the impugn award dated 6/11/2018 by which 25% of the net present value was awarded to the respondent number 3 to 11 is illegal, arbitrary, and section 107 of so and so Act never authorizes respondent number 2 to award any compensation under State Rehabilitation and Resettlement Policy 2008, and therefore Mr. Tiwari has contended to set aside the impugn order to modify the same by deleting the net present value. So what he submitted is that we are not entitled to get the benefit under the RR policy of 2008. Or you please delete that 25% of the net present value. Now, how this court proceeded, my lord will kindly skip 10.1. Now, my submission to this is 11.2 at page 30. 11.2. Further submission of Mr. Das is that a petition and WPC so and so are ready to accept the compensation of the LARA Act 2013 if the NHPC has assessed the compensation total compliance of the provision for assessing the compensation as laid down in the schedule of the LARA Act 2013 and the award the compensation under section 29 of the Act for the forest and crops standing on the acquired land, and a DC Lower Dewang Valley district respondent who has rightly assessed the compensation, and the same requires no interference of this honorable court. Now, page 50, kindly see. Certain issues were framed by this court at page 31. Certain issues were framed. Now, my lord will just see para now. All the issues was discussed in details by this honorable court. I will not trouble this court. See at page 51. PC 51, para 20, sorry, my lord, page 50, para 22, which a written argument was given. It is noted that Mr. Tiwari, learned senior counsel for the petition in SPC, so and Mr. Das, learned senior counsel, petitioner and for private respondent, has submitted written synopsis for argument. From a perusal of the written argument and also from the submission of Mr. Tiwari, it becomes apparent petitioner NSPC in WPC is agreeable to pay compensation to a petitioner in WPC number 230 and for private respondent number 3 to 11 as per mandate of LARA Act 2013. Mr. Das, learned senior counsel petitioner in WPC number so and for private respondent number 3 to 11 has agreed to accept the compensation if assessed under the LARA Act 2013 in the event of payment GIRAT to the petitioner as while assessing the compensation under section 29 was not taken into account. Now please further see para 23. Mr. Tiwari, learned senior counsel for the petitioner NSPC in WPC number 242 2020 and respond number 1, 4 and 5 in WPC is agreeable to pay compensation to the respondent number 3 to 11 in WPC and petitioner in WPC number so and so, whatever they are entitled to under the LARA Act 2013. And since Mr. Das, learned senior counsel petitioner in WPC and so is agreeable to accept the compensation, whatever they are entitled to under the said act, this court is inclined to dispose of both the writ petition with the following direction. So there was a clear undertaking which was given by the NSPC and we have agreed to it. This was an agreed terms and condition of both the parties. Now please see further A. Respond number 2 in WPC and respond number so and so, what was the first direction that was passed? Shall constitute a board to reassess the compensation with the petitioner in WPC number are entitled to for acquiring this land as Viswanagar at so and so. B. The board shall be constituted with adequate representation of NSPC. C. Board shall assess the compensation in each of the components as specified in first schedule of so and so in seriatim and further take into account the provision of section 29(2) which provides for determination of value of thing attached to the land or building. D. Respond number 2 in WPC and respond number 3 in WPC so and so on his satisfaction about compliance of all the provision assessing the compensation by board, so constituted shall pass the award incorporating therein 12% interest per annum on the market value of the land as provided in section 33 of the Act. E. The aforesaid exercise has to be carried out within a period of 3 months from the date of receipt of the certified copy of this order to facilitate reconstitution of the board and to make fresh assessment and to pass fresh award, and the impugned award dated so and so approved by the government of Arunachal Pradesh stands set aside and quashed. So now there was an agreed terms and condition. Your Lordship discussed the judgment in details. In detail the judgment was discussed. Now once the judgment was received by us, immediately we communicated, my lord, at page 53. on 13/2/2025. Now, subject kindly see, my lord, on the basis of the judgment that was passed, immediately we have said that you please constitute board for assessment and to make award within the stipulated time, because your lordship has granted 3 months time to complete this process. Now, please now look into again the list of dates, my lord. Please see the list of dates again, my lord. Your lordship was looking to it, list of dates, 10th of February. This is a judgment, Mr. Sir. Next date, kindly see, my lord. Now, thereafter, my lord, having no alternative, my lord, what we have done, we file a contempt application before this honorable court. Now, the contempt application which was filed before this court, this is the contempt. Now, kindly see, my lord, on 14/5/2015. Now, see this 13/2/2025. In 13/2 I have shown. Now, kindly see the IA, kindly take my IA. Please take that IA, additional affidavit, my lord. Lordship got it? Please take the additional affidavit which we have filed. An additional affidavit was filed in this contempt, which starts from at page 162, my lord. 162.
Page number
162. 162 it starts.
Yes.
Yes, my lord, that's an additional affidavit. Please look into the order of this court at page 171 to 170, which is list of dates also have written. That is, once the contempt was filed, my lord, they were not complying. See the order of this court, my lord, at page 174. 174, lordship got it? 21/5. By filing this application, a prayer has been made for extension of time to comply with the judgment order dated 10/2/2025. It is submitted. Compliance of the order involves assessing and paying the compensation. And in this regard, steps has been taken in right earnest, so and so, so and so. Prayer generally object by so and so. So now, if your lordship says 175, some time was granted by the court to comply with the court's order. Please see the last paragraph. After considering rival submission, also the subject matter involved, this court is of opinion present prayer may not be held to be unreasonable. However, this court is not inclined to grant a month's time from today, as independent more than 3 months have already elapsed. According, extension of time for compliance granted by 3 weeks. Now, thereafter, in 3 weeks, they could not complete the award, my lord, the process. Now they file another second application for extension at page 176. 176. Lordship got it? 176. Please see, this order is important, my lord. At page 179, the order dated 10/6/2025. Now, if your lordship looks into the order, first, the as Tapin, learned state counsel appearing for the applicant, also heard Mr. Rava, learned counsel for opposite party writ petition, and Mr. Saxena, learned counsel for the opposite party respondent. So, NSPC were represented by my learned friend on that day. So, my learned friend's client was aware that the contempt application has been filed. They can't say, my lord, they represented the counsel because GM appeared. When contempt was filed, the GM was also made a party, others also were made party. So my learned friend appeared on behalf of the NSPC. The NSPC authority here appeared. Now kindly see, find this application. Applicant has paid for extension of 3 months' time to comply with the common judgment order. As Tapin learned counsel for the applicant submit, although this court has further granted 3 weeks' time for compliance with judgment in IA, extend time for compliance. However, due to transfer of the earlier incumbent DC, steps that were required to be taken could not be completed. Issue of payment of compensation involve assessment of which many factors have been taken in consideration, which the applicant has taken in right earnest. Same could not be completed as there remained certain issue to be considered. Therefore, he submitted 3 months time can be granted, so and so. Now kindly see 5. Having considered the submission of the learned counsel of parties, considering that certain process has to be completed for proper assessment for the compensation as agreed by the learned counsel of parties, I am inclined to extend further 2 months time for compliance of the judgment order, so and so is extended. And so now this order, my lord, passed by was complied by the deputy commissioner, whereby your lordship will kindly see at page 181 now. At serial number 16, list of dates, my lord, see at 181. Now this is the award which was prepared. Now if your lordship kindly see, first is very important, my lord, 181. In view of the judgment, so and so, to dispose the company matter with period of 3 months and additional extension of, so they referred. See para 1, my lord. As directed by the Honorable High Court, a board of officers was constituted with representation of NHPC. The board has assessed the survey report and reassessment based on section 2930 has been prepared with proper parameters and latest rate as per manual of land acquisition in Arunachal Pradesh 2022. Now, my lord, will please take this into account. Why I am saying, my lord, now the present writ petition which they have filed, and they were aware, and my lord was directed, given a direction, a board to be constituted. Board to be constituted means the NSPC has to be present, and their officers were present when this was assessed, and they were aware of it, my lord. The board has assessed this survey report, and reassessment based on section 2930 has been prepared with proper parameter and latest rate as per manual of so and so. Now, number 2, the original award categorized the land as horticulture cultivated so and so, or cultivated so and so. Now this, my lord, was done. Now, so this is was sent to for meeting for sending it to the this state, my lord. Now, if your lordship kindly see it, my lord, this was sent to the state for approval, and at page 187, this was approved by the government. Lordship got it, my lord? It was approved. Now, my lord will kindly see very interesting letter where at page. Now, please look into it at page 187. Now, if lordship, I am just troubling with one of the annexures, which is a part of the my IA 320. Please look into 320, my lord. I am just troubling with this at page 15, my lord, because that is in sequence order, page 15, my lord. IA, my lord, 320. 320, no? Page 15. After the judgment was passed, please see, we have assessed page 15. Please see, my lord, 29 of July 2025, that DC has written to the Executive Director, my lord, NSPC. Very important letter, my lord. On 29th of July 2025. This judgment, my lord, government approval. Now judgment stated 2-3. See the last paragraph. You are requested to deposit the award amount of 48 crores so and so to the joint account of so and so at the earliest, so that exercise is completed by 10th of August 2025 in line with the judgment, order and extension given by Honorable High Court, and to communicate to the Honorable High Court regarding compliance of the same. Now, my lord, will please see. Now, my lord will kindly see back to the contempt now at page 187A. 187A. Kindly see now. Page 187A, my lord. That is 29/7/2025.
Yes.
Now see the now the NSPC returned back to DC on that letter, 29/7/2025. Para 3 and 4 kindly we see, my lord, para 3 and 4. Why judgment dated 10/2025, Honorable High Court has directed only for fresh assessment of the compensation and passing of fresh award after reconstitution of the board. Subsequently, while disposing of the IA, so Honorable High Court vide order dated 10/6/2025 has extended the time by further 2 months for compliance of the judgment order passed in so. 4, my lord. Honorable High Court, now what they said, see please, my lord. Honorable High Court has not directed to deposit any compensation at this stage. Deposit of compensation amount by NSPC and subsequent disbursement may be considered only after passing of any order by the Honorable High Court in that matter. I don't understand, my lord, this type of letter. That is why also subsequent, this Honorable Court, while looking this order, was annoyed and said that there is a contempt. I'll show that, my lord, by showing this line, my lord. Now what he says, kindly see, in view of above, it is submitted that upon receipt of the final revised award and further direction from Honorable High Court in the matter, NSPC shall take immediate steps for the deposit of the compensation as desired by the office letter dated 29/7/2025. We assure of our continued commitment in complying with all legal direction and statutory requirement. So this letter, now thereafter, DC has replied at page 188. Please see that DC's reply at 188, 1st of August 2025, my lord. Now, if your lordship, 190, please look into 190, my lord. At paragraph, my lord, C, my lord, will kindly see. C, paragraph C. The direction of the Honorable High Court in order dated 10/2025 and through further extension is explicit in that the exercise of compliance of the order is to be completed by 10th of August 2025. Along with the order issued for compliance order in para 23 of the order dated 10/2025, para 24 of the judgment categorically dispose of all the writ petition in this matter. There is no direction, implied or otherwise, in the judgment that the award is to be submitted to the Honorable Court for examination approval. It is specifically mentioned that DC is the respondent number 2 in WPC number so and so and respondent number 3 in WPC number so and so shall pass an award on his satisfaction. As clarified earlier, the board report was prepared, examined to the satisfaction of DC collector, and award computation attached as addendum to the board report. It is submitted to the government for examination as State of Arunachal Pradesh represented by so and so is also respondent in so and so. Based on the approval of the government, revised award passed on 1/8/2025 by DC is enclosed as Annexure A. Now, if your lordship kindly see at E, the entire process of preparation of award to deposit of compensation is implied to the judgment order dated 10/2025. There is no direction that the award is to be submitted to the Honorable Court for passing of any order by the Honorable High Court. Rightly, the Deputy Commissioner has said, where is the question of giving another direction by the court? Once the award has to be assessed, then automatically you have to pay the compensation to the. This is what this says. Now, my lord, 192 is a detailed award that has been passed, 192 on 1st of August. After that. Now, my lord will kindly see. Please, my lord, I'll trouble with list of dates once again, my lord. There are only 4 lists, some few lists of dates which is relevant now. I have given a background of this case. List of dates going to ask. My lord will kindly see at 22, serial number 22. Quota, sir. Head code 48. 48/2025. Please look into 48. Only I just read this, my lord. 48. NSPC admitted in their IA 304 of 2025, that IA of maintainability, my lord, that the award was received in the head office of NSPC. So it is admitted by them, it was received on 4/8/2025. Then see next date, 2/12/2025, NSPC prefers ISC 304/2025 in contempt, challenging the maintainability of contempt petition of the petitioner. 8/12/2025, petitioner filed the objection ISC 304 of 2025. Now, 22/12/2025, petitioner prefers IA 320 of 2025 in contempt case 15 of 2025, praying for a direction from this honorable court to direct the NSP deposit the awarded compensation while award dated 1/8/2025 for appropriate disbursement to the petitioners. Now, if your lordship now, 28, they file objection on 28/1/2026, my lord. On two grounds, primarily on two grounds. One, the adjudication is not possible without deciding the maintainability of the contempt petition. Next, contempt is not maintainable qua NSPC as there is no direction for deposit of the compensation, the judgment and order dated 10/2/2025. Now, my lord will kindly see 4/2/2026 order. The Honorable Court in contempt case number 15 of 2026 observed that the official of NSPC appears to be in contempt on the face of it. Further, on the basis of submission made by the NSPC, the Honorable Court, under exceptional circumstances, granted time until 18/2/2026 to take appropriate instruction with regard to the steps taken for the compliance of the order in question. Please now see that order. That order will be relevant for the consideration of this court. That order was passed on 4/2/2026, my lord. Four to 2026, which your lordship will find your lordship got 4/2/2026 order. I'll say copy. Your lordship got the order. Now I just read this order. Please see, my lord, my learned friend Tiwari also appeared. And if your lordship, the contention at next page was reproduced by this court. Kindly see, this court, after hearing the content, has disposed of the for both the relevant part of which is seen. 23 is quoted, my lordship got it. 23 is quoted. Now everything quoted. Now kindly see next page. It is a case of the petitioner that though there was direction for constitution of a committee, the same was not done according to present petition for contempt was filed. Same was followed by filing two interlocutory application by so and so, was disposed of by the order dated 10/6/2025 by granting further extension of 2 months for compliance with direction. Finally, while communication dated 16/7/2025 made by DC Lower Dibang, the appropriate land management department of state, was forwarded with the aforesaid award which was approved on 28/7/2025. NSPC has however issued a communication on 29/7/2025 from which it appears that the particular officer was under the impression that further orders are required to be passed for disbursement of the amount in question. Said officer has erred as a respondent of 5 in the present proceeding, so and so. Mr. Tiwari, learned senior counsel, appears for 3 of the officer. NSP has however submitted communication dated 29/7/2025 appears to have been issued with a wrong understanding of law, which however is without any mala fide. He has submitted there may be good ground for challenging the present approval award dated so and so for non-compliance of certain provision of right to fair compensation so and so, so and so. This court is however of the opinion that the final approval of the aforesaid award was given by government way back in July 2025 pursuant to a judgment which was passed on 10/2/2025 on extended period of time. almost 8 months have elapsed since such approval. In the backdrop of the aforesaid development, issuing the communication dated 29/7/2025 appears to be contemptuous on the face of it. So that letter of 29, be it so and so has submitted, some time may be granted to take approval with regard to steps taken for compliance of the order in question. Now please see now last so and so, be that as it may, as an exceptional circumstances, this court grants time to so and so to obtain necessary instruction. So what was the direction that was passed by this court? The court found that your letter of 29/7/2025, only you cannot write this type of letter that we want a further direction of the High Court. Where is the question of further direction of this court? The court adjudicated the matter on 10/2/2025, passed an order, reassessment was done. Your board member was present, my lord. And the court has said that what you are saying, 29/7/2000, Deputy Commissioner said it is implied. Once you have assessed, you have to deposit the amount. Now, this court, while looking into that, the court said that what type of your officer is saying, it appears on the face it is contemptuous. Who is the executive director of NSPC, my lord? So the court said that, okay, what we will do it, we will give some time to you for compliance of the order in question. You come back and let us know. Now, instead of coming back for compliance of this order, what they have done, my lord, please see the list of dates now. See page 28, my lord, serial number 28. Instead of obtaining necessary instruction in terms of the order dated 4/2/2026 passed by this honorable court, NSPC in circumvention and to avoid the pending contempt petition, preferred writ petition seeking 1. Setting aside award dated 1/8/2025. Number 2. Withdraw and denotify the land acquisition notification dated 30/8/2018 to prepare and notify a revised update and policy complaint. 4. To utilize the available government land in possession before undertaking acquisition of private land. 5. Restrain from demanding, recovering, or enforcing payment of any compensation amount pursuant to the award dated 1/8/2025. Now, they have come and filed a writ petition only for the purpose that to circumvent the court's order. Now, if your lordship looks into the contempt, there are two parts. Whether how the apex court has dealt this type of case, whether any interim order can be passed in a contempt or not. This has to be looked into it. Now, my lord will kindly see what observation that has been made, that whether the writ petition is maintainable or not. Now, the order that was passed on the first day, if your lordship looks into it, the writ petition, when it was moved by this honorable court, please see the order of the writ petition, how the court has taken that writ petition. Please look into the order that has been passed by this court. 18.2. Kindly see the order of 18.2, my lord. 18/2/2026 order. Please see the order. 18.2.
Yes.
18.2. Challenge made is writ petition is to the award dated 1/8/2025 passed by DC so and so, measuring so and so has been acquired for total company amount of so and so. Ratan so and so appear. Now kindly see. Considering that the award has been passed pursuant to the judgment and order of this court as agreeable by the learned counsel parties in the earlier writ petition, which prima facie appears to be a consent order, and in view of the submission made by learned additional solicitor agreeing to deposit the complaint amount, it is hereby provided petitioner shall deposit the said awarded amount so and so before this court within a period of 20 days from today without prejudice to the claim of the petitioner. Now, my lord will kindly see what was the observation that was made by this court. When the matter was taken up by this court while passing the judgment on 10/2/2025, it was a consent. Both the parties have agreed to it, and it was a consent order. So there is no question now to file a writ petition only for the purpose of circumventing the order of this court. This court has passed the order on 10th of February 2025. And to what extent the writ petition is not maintainable, very limited ground, my lord. My ground is one, it is barred by doctrine of constructive res judicata. And they are stopped now. Two grounds on maintainability, which I have raised this ground. One on the point of doctrine of constructive res judicata. Another ground is on the point of principle of estoppel.
My
They
lord,
cannot raise this point now.
may I submit this,
Yes,
my lord.
I am going. No,
Wait a minute.
Mr. Raju,
Wait a minute. My
Yes.
submission is, let the contempt application be heard first, thereafter the writ petition. Why is he addressing on writ petition? You can address.
No, we are in the contempt
After
petition.
after
Mr. Raju, we are in the
contempt
contempt.
application.
We are in the contempt petition now.
Yes.
Yes.
The contempt petition, let me reply. Thereafter, he can say in result. Why is he referring to the writ petition?
He is continuing with the contempt petition.
Only what I am saying, my lord, only to circumvent the order of this court, they have filed this writ petition. And whether now I'll submit further, not now, let me place the contempt judgment before this honorable court. Now please see the judgment of this court, of this Supreme Court, my lord. 2024, my lord. SCC Online SC 3727. 2024 SCC Online SC 3727. What you got it, my lord? Please see para 192, my lord. Para 192. 192. What you got it? 192, my lord.
Yes.
Yes. In Rita Markande versus Surjit Singh Arora, 1996 6 SCC, it was observed that even if parties, now my lord, it is a worst case, even if the parties have not filed an undertaking before the court, but if the court was induced to sanction a particular course of action or inaction on the representation made by a party, and the court ultimately finds the party never intended to act on the said representation, or such representation was false, the party would be guilty of committing contempt. Now, what is the case in hand, my lord? At para 23, your lordship clearly has stated that the party has agreed. So there was some inducement that was given to the court on 10th when the judgment was passed, when the matter was heard by this honorable court. Argued, the matter was argued. And my lord, in this case, at para 192, it is a worse situation. My lord will kindly say, even if the parties have not filed an undertaking before the court, but if the court was induced to sanction a particular course of action or inaction on the representation made by the party. So what was that, my lord? That was in respect that no, you are not entitled to get 25% of net present value. What we are agreeable as an HSPC, we are agreeable to pay compensation under LARA Act, which we said, okay, we are agreeable to accept. So on the basis of that inducement which was given, that only those following direction was passed by this court. Here is a case, my lord, para 192, that even undertaking is not being filed. If there is some representation which is mailed by the parties, even then it will amount to contempt. Party would guilty of committing contempt. Relevant observation read as follows. Para 196, please look into now 196, my lord. 196 now. 196. What can be discerned from the above exposition of law is that any act of disobedience, defiance, or any attempt to malign the authority of the court would amount to contempt because they undermine the respect and trust that the public reposes in judicial institution. Judicial process relies on the confidence of society, and any act that disrupt or disrespect the process threaten to erode the foundation of justice and order. Contempt jurisdiction exists to preserve the majesty and sanctity of law. Courts are the guardian of justice, and the decision must command respect and compliance to assure the proper functioning of society. When individual or entity challenge the authority of courts to willful disobedience or obstructive behavior, they undermine the rule of law and create the risk of anarchy. Contempt serves as a mechanism to protect integrity of the courts, ensuring that they remain a symbol of fairness, impartiality, and accountability. 198. When judicial orders are openly flouted or court proceedings are disrespected, it sends a signal that the rule of law is ineffective, leading to a loss of trust in the system. Judicial decision must remain unimpaired, free from external pressure, manipulation, or circumvention. Acts that attempts to mislead the court, obstruct its functioning, or to frustrate its decision distort the process of justice and would amount to contempt. So whatever they submitted before the court by NSPC, that we are willing, that it absolutely was not correct. They want to frustrate his decision only to distort the process of justice, which is amount to contempt. Now please see 199. The very important, my lord, the contempt jurisdiction of this court cannot be construed by any formulaic or rigid approach merely because there is no prohibitory order or no specific direction issued the same would not mean that the parties cannot be held guilty of the contempt. Now, what is the case, my lord? What it say? They say that they want a specific direction of this honorable court. They are saying, my lord, in letter of 29/7/2025 by the NSP executive director, no, the deputy commissioner direction is there, but there is no specific direction which is given by the court. Now, my lord, what they are saying, they stand true now also. Where is that contempt, my lord? In a land acquisition matter, your lordship has much more experience. Land acquisition matter, there cannot be any specific direction. When a acquiring authority, my lord, who has asked for this land? I am asking my question to NSPC. They want a project. They requested the government that we need land. My lord, I am making it very clear, my lord. Your lordship has dealt number of cases in Arunachal Pradesh. The land system is completely different here. I will go through that land system in WPC, which my learned friend has said that find out government land. There is no such concept as a government land here. Whoever goes and settle, it becomes their land. And ultimately that land is acquired, that becomes a government land, my lord. Your lordship has got experience. Forest land, my lord. All Itanagar, I remember all Itanagar is a forest land. All Itanagar, everywhere, my lord. Either it is a community land or a clan where they cultivate, my lord. If they can't say that provide with an alternative government land, where is that government land, my lord? You are the requiring authority. You requested the state. State accordingly has acquired that land. Now further kindly see, my lord. Merely because there is no prohibitory order on a specific direction issued the same would not mean that the parties cannot be held of guilty of contempt. The contempt jurisdiction of this court extends beyond the mere direct disobedience of explicit order or prohibitory direction issued by this court. Even in the absence of such specific mandates, the deliberate conduct of party aimed at frustrating the court proceedings or circumventing its eventual decision may amount to contempt. This is because such action strikes at the heart of judicial process, undermining its authority and obstructing its ability to deliver justice effectively. The authority of courts must be respected, not only letter of their orders, but also in the broader spirit of the proceeding before them. 200 minor. Any contemptuous conduct to the parties to bypass or nullify the decision of this court or render it ineffective or to frustrate the proceeding of the court or to inure any undue advantage therefrom would amount to contempt. Attempts to sidestep the court jurisdiction or manipulate the course of litigation through dishonest or obstructive conduct or malign or distort the decision of this court would inevitably tantamount to contempt, since any prohibitory order or direction to such effect. 201, my lord. Thus, the mere conduct of parties aimed at frustrating the court proceeding or circumventing its decision, even without an explicit prohibitory order, constitute contempt. Such action interferes with the administration of justice, undermine the respect, authority of judiciary and the rule of law. 200, my lord will kindly, 205 kindly see, my lord. 205. Where a decision is rendered and the impugn order is set aside, it behoves any logic that an express direction to act must be given in respect of every aspect of the decision, which now they are saying, my lord, that direction should have been passed. It is implied. The parties are duty bound to act in accordance with common sense. It is axiomatic that a party should obey both the letter and spirit of a court's order, and it is neither open for the parties to adopt a myopic and blinkered view of such decision, nor any such interpretation or view that subserves their own interests. It ultimately, the purpose for which the order was granted, that will be a lodestar in guiding the parties as to the true effect of the order and determination of the court. 222, my lord, kindly see now. 222. This is important. 222. 222. Similarly, a three-judge bench of this court in the case of State Bank of India so and so, in clear terms, said that apart from punishing the contemner for his contemptuous conduct, the majesty of the law may demand that appropriate direction be issued by the court so that any advantage secured as a result of such contemptuous conduct is completely nullified. The approach may require the court to issue direction either for reversal of the transaction in question by declaring said transaction to be void, or passing appropriate direction to concerned authorities to see that contemptuous conduct on the part of the contemptor does not continue to inure to the advantage of the contemptor or anyone claiming under him. So what we have filed, that's why an application was filed, to just to keep the order of this court of 10/2025. So that doesn't undermine the order of this court. Either this Supreme Court in 3 judges said that no, it is Bijay Malia's case, my lord. Either whatever the amount that will reverse back, or you have to pass such direction in a contempt. So it is not a case that in a contempt a direction cannot be passed. Now the law, my lord, with great respect has changed. Earlier, my lord, contempt is, my lord, only a contempt. It has been put into imprisonment. That's only. It is not like a civil court, my lordship is aware. A decree is passed and the execution proceeding. Now, to the extent to what extent the court has gone, my lord, in contempt. Now, I will show one judgment of this, another judgment of the Supreme Court, my lord. 2024, 11 SC 679. 2024, 11 SC page 679.
Yes.
Now, 15 kindly see, my lord. 15. However, in Mazdoor Sangh versus so and so, aforesaid precedent, a 2-judge bench of this court noted 3-judge bench has clarified there in a direction which are explicit in the judgment or are plainly self-evident can be taken into account for purpose of considering whether there is any disobedience or willful violation. The bench further held that the court has a duty to issue appropriate direction for reminifying or rectifying the things done in violation of the court's order. And in that regard, court may even take restrictive measures at any stage of the proceeding. So it is not that we are barred, my lord, application cannot be filed for passing an interim order. That's why we filed that application. Now see para 16. Significantly, the 2-judge bench has merely echoed the affirmative of the legal position of another 2 bench of this court in so and so. Principle that a contemptor ought not to be permitted to enjoy and to keep the fruits of this contempt was reiterated therein. Reference was made by this bench in so and so, where it was held undergoing punishment for contempt would not mean that a contempt is not entitled to give appropriate direction for remedifying and rectifying the things done in violation of this order. Therefore, the principle that stands crystallized by the judgment is that in addition, please note that in addition to punishing a contemptor for disobeying its order, the court can also ensure such a contemptor does not continue to enjoy the benefit of his disobedience by merely suffering the punishment meted out to him. So it is not a case that your lordship cannot invoke a jurisdiction to pass appropriate order in this case, which we have filed. Last judgment of the Supreme Court, I will show one judgment, 2026, SCC, online SC 322. One more judgment is there, my lord. After this, my lord. My lord, I think this judgment, with great respect, my lord, this judgment has a connection with the writ petition, my lord. Please see para 6 and 7 is the facts, my lord. Which is related, kindly see please para 6 and 7, my lord. 6, my lord. My lord, will kindly see next page. After para 6, my lord, if your lordship turn to para 6, from the top, my lord, 1, 2, 3, 4, 5, one line. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. We must, lordship got it? We must unequivocally state, hearing that while no fetter could be placed on preferring a review petition, it was the duty of the LS contemptor to first comply with the order. Depending on the outcome of review petition, further steps, adjustment could have possibly taken place, but it was not open to the LS contemptor to not comply with the order of this court on the mere filing of a review petition, which at a deliberate cost of repetition remains defective due to want of rectification by the concerned review petitioner. Now 7, incredibly, the affidavit also states that if court does not find merit in the so and so, immediate steps to comply will be taken as a logistical hurdles have been figured out. Therefore, it is quite clear that at least as on date, the LS contemptor could very well have purged the contempt out, but chosen not to do so. Now this, please see paragraph 23, kindly see, my lord. Paragraph, see para 23, my lord. Simply put thus, it is no longer res integra that a party once become or is made aware of an order of this court, if yet acts in willful default or deliberate non-compliance or any such like conduct against in breach of the order concerned, makes itself liable to face the full wrath of contempt jurisdiction. In the case at hand, the government and so has been aware of the order at the very least, and onwards as clear for correspondence placed on record, affidavit so and so. Now please look into paragraph 27. Now this, how the court dealt last, my lord, 27. Belated delays, my lord. They were waiting for 8 months and they were not doing anything, and they have filed a writ petition at belated stage. See para 27, my lord. Para 27. Delay filing of appeal should be the exception, but in recent times, the exception has practically evolved to become the rule. Orders passed by this court are not complied with for a long time, and when contempt petition are filed, belated appeal with tremendous delays are preferred. Here 8 months, my lord, they waited, and thereafter writ petitions are being filed. The LA's continuing contemptuous conduct of the defaulting party is sought to be justified on the mere production of diary, filing, step reporting numbers, showing that an appeal has been preferred so as to obtain multiple adjournment in contempt matters. We, in no uncertain term, deprecate these practices, it is felt that by such modus operandi, disobedient litigants act brazenly, which has a further effect of bringing down the authority and majesty of the court and the rule of law. Inferring in the administration of justice, the same very well in certain situations border on criminal contempt. 30, the High Court should deal with such unscrupulous litigants more so when they happen to be state within the meaning of Article 12 of the Constitution, or like bodies with an iron hand. Unless the High Court so also this court deals with this aspect firmly, we run the clear risk of erosion of the unflinching faith that the ordinary litigant of this country reports in the judiciary at all levels. It is a solemn duty of all us manning the court across the hierarchy to ensure the public faith never wavers. Now see para 32, my lord. Copies of the judgment be also circulated to Union Secretary, Department of Personnel Training, Chief Secretary, all the state government, Union Territory and Government of National Capital, so and so, with the direction to take note of what we have stated above in respect of contempt petition, whether pending before this court or the High Court, where officers stand aired or as individual, they are at liberty to transmit the judgment onward as deemed fit to other officers as concerned person. So my lord will kindly see why I showed that writ petition, and my learned friend said that he is going into writ petition not for that purpose. To show that writ petition they have filed only to circumvent this order of this court, that is 10/2/2025. Now the last judgment of this court, of the Supreme Court, my lord, 2025 SCC online SC 3931. 2025 SCC online SC 931. Only two paragraphs, 31 and 36, my lord. 31 and 36, my lord. The power and jurisdiction of this court to initiate and punish for its contempt has not been disputed. It is well settled by now and is apparent from the provision of Contempt of Courts Act and civil contempt being willful disobedience of judgment, decree or direction, order, writ or other process of the court, or willful breach of undertaking given to the court. My lord, what I am saying, this is some type of undertaking which is given the consent of both the parties. And please see 36, my lord, last paragraph. A party misguiding the court to pass an order which was never intended to be complied with. I'll pause for a moment. Why this, my lord, submission was made? We are agreeable to it. That's the reason why this court has passed that order. Which would constitute an act of overriding the due process of law and thus commit contempt of court in the instant case, the opportunity having been availed, time having been short also granted by the court, further reflects the intent of the respondent contemptor to discard and tarnish the judicial process by polluting it. Disobedience of the order of the court in such circumstances would be the only result and thus civil contempt. Now in the IA, we have pleaded, my lord, that your lordship just can mark it. IA 320, we have made a pleading, paragraph 9, 10, 9, 10, and my lord, and 11. This pleading has been made in IA 320, my lord. So what pleading we have made? We said that you have to they release the money, and secondly, they should be held of contempt in the main contempt petition. Paragraph 8. Paragraph 8, my lord, this and 9, 10, this is release of the amount. They, my lord, your lordship has seen that they cannot take my fruits and they can enjoy. This is like a decree has been passed and my fruit, my lord, they are enjoying it. And they are, what they are trying to do it, they are filing a writ petition. What the court said that how can you file it? You are circumventing the court's order. My lord, what the court said that some review petitions are being filed. Defective, my lord, it has been filed. Court said that no, it cannot do it. is only that you want to take time, only for the purpose that you don't comply with the court's order. And my lord will kindly see this writ petition, which was moved, that has not been stayed by this honorable court. Your lordship's order has not been 10 to 2025 order has not been stayed. Nor the award has not been stayed by this court. With due respect, my lord. And when the matter was moved, your lordship has looked into it. The clear expression passed by this court, it is a consent which was given by the court. So my case before this court is a clear contempt. It is not that there has to be an implied, expressed order passed by this court. What they are saying that this is, my lord, their case, it is not maintainable. Why it is not maintainable? On the ground that the order that has been passed by this court, there is no implied, there is no order. There is no explicit order that has been passed by the court. Like lordship has said, the award, they said, now deputy commissioner has passed the award, so that is end of the matter. That means they want a separate order passed by the court. Deputy commissioner said in a earlier case, where is the question of the separate order to be passed by the court? It is implied. Now, my lord will kindly see the land manual of 2020 of 2022 of the Arunachal Prasan. Now, please see this, my lord. I think this, I don't know whether it will not. What is it? Divo lagibo, no? Last time billing judges. Please see 25. Land manual is automatic, my lord. Kindly see, my lord. 22, my lord. 25, my lord. See 25. So how they can say, my lord? And my lord, with greatest respect, my lord, what I am saying, this person should not be scot free, my lord. They may be a corporate giants. It is a different, with great respect, I am saying, the CMD, the executive director, all are liable for contempt, my lord. They are liable to be held contempt and they should not be left, my lord. In fact, they should be called in the court. And why they have not disobeyed, why they have disobeyed the court's order and why they have not complied. And my lord will kindly see, the last order that has been passed by this honorable court was on 4/2/2026. They said that, yes, what do you say? On the face of it is contemptuous, the court said. How can you ask that another order should be passed by the court? So my respectful submission before this court is that we don't want that this money which is deposited, that it should be given to us. They should immediately deposit before the deputy commissioner accounts, my lord. The deputy has already given the account and accordingly it will be disbursed by the landowners. That's what we want, my lord. And there, my lord, have seen all the judgment of the Supreme Court. These 2-3 judgments, subject to your lordship acceptance of what my learned friends say about the judgment, whether any interim order can be passed for remedifying or rectifying. So this judgment clearly said, not only the punishment, there are other modes also where the court can look into it. So this is my respectful submission so far as contempt is concerned. And I will give a reply. So his writ petition is concerned, my lord. Why it is not, after my learned friend Raju, my lord, gives a reply, I'll give a reply, I'll submit in 10 minutes, my lord, why this writ petition is not maintainable on the face of it.
All right.
Yes.
Yes, Mr. Raju.
I think
Mr.
you are,
Raju, you are not audible. Unmute, please unmute.
Yes, I'm sorry. But contempt can be either civil contempt or criminal contempt. This petition is for civil contempt for disobedience. Now, my lords may kindly have a look. Therefore, there has to be a direction on an order or an undertaking. Admittedly, there is no undertaking. There is no undertaking given by NHPC or any of the officers or any of the contemners. Now, my lords may kindly note a few dates. My lord, as far as the matter is concerned, give me that page, list of dates. List of dates. The what is alleged is breach of the order dated 10th of February 25. My lords may kindly note that there is a breach of order of 10th of February 25. And the contempt petition was filed on 14th of May 25. On 14th of May 25, there was no award. There was no question of complying with any award, assuming that I was required to comply. I'll point out I'll point out as far as compliance is concerned, my submissions are different. This is not a contempt petition filed after the award was passed. This is passed even before the award was passed. It is filed even before the award was passed. Can he file a contempt petition saying that, assuming that I was required to comply with the award in the manner in which the award is passed? I have a serious contention as far as the method and manner and modus in which the award has been passed. Whether it is an award as per the directions of this Honorable Court is a moot question that is required to be seen. So even before the order is passed, a contempt application is filed saying that you have committed contempt of what? My learned friend is arguing an award which is passed. The date of the award is August. 1st of August 2025. So on the date of the petition, when it was filed in May, there was no award. How can I be held guilty of an event that is to be taken place in future? Unheard of in contempt proceedings. Unheard of. So in May, when the petition was filed, there was no award. How can my learned friend argue that we have committed breach by not complying with an award that was not in existence on 14th of May 25? So he assumes and presumes that there is going to be an award in August which you are not going to comply with, which you are required to, even is assuming that I'm required to comply with and make payment is also an assumption. I'll point out it's not a need, there's no direction. And then he files a contempt petition in May 25. Therefore, the contempt petition is premature. Even if I accept the submissions of my learned friend without accepting them to be true. Therefore, on this ground alone, the contempt application is required to be rejected. Admitted fact, order is dated 10th of February. Contempt petition is filed on 14th of May. Award is in August. Therefore, there was no award in existence on the date of the contempt application. How can there be contempt? How can there be compliance with the order? Supposing your lordship had heard this matter on 4th of May 25 when the contempt petition was filed, 14th of May. It is a coincidence that this matter is being heard today. But if it was heard on 14th of May, it would have been premature. Could he have argued that there's an award, comply with it? He could never have argued. If he could never have argued when he filed the petition, how can he now argue it? If there's any subsequent development, if there's any subsequent breach, he has to amend or he has to file a fresh contempt. This contempt doesn't lie. Therefore, on this limited ground, the contempt application is required to be rejected. Has to be looked in the background of the fact that I've deposited the award amount in this Honorable Court, which shows my intention. My intention was never to flout anything, but my intention was always one of others. Why would I have deposited the award amount in this Honorable Court? Now, kindly come to the facts of this case. Kindly come to the directions given. Kindly come to page 51.
Yes.
Page 51. There's a direction.
Yes, yes.
This direction is
Yes,
not
got it.
page 23, 51, para 20. This direction is not for any future event that has to take place in August. Now kindly have a look at the directions. Since Mr. Tiwari, learned senior counsel for the petitioner NHPC in writ petition so-and-so and respond number 1, 4 and 5 in writ petition so-and-so is agreeable to pay compensation to respond number 3 in so-and-so petition so-and-so, whatever they are entitled to under the so-and-so Act 2013. So what is the statement? I am agreeable to pay as per this, if the award is as per this Act. Supposing the award is not as per this Act, am I bound to, does it say, no, but whatever is the award, whether it is under this Act or not, you have to pay because it's an award? That can't be. My agreement is not to pay any and every award. The so-called agreement which my learned friend is saying, even if it is assuming that there is an agreement, is to pay if the award is as per the 2013 Act. If it is not as per the 2013 Act, I am not bound to pay. I am bound to point out that this is not as per the 2013 Act. I am not required to pay. So award has to be within the four corners of the 2013 Act. That is precisely the reason why I am challenging it, saying that it is not under the 2013 Act. My right to challenge an award, supposing, your lordships, I am giving a hypothetical illustration. Supposing they pass the award and not under this Act, but under the Land Acquisition Act, and pass it, am I not entitled to that? So, sir, I am not supposed to make this payment, even it is assume that there is a direction for me to pay that amount, which is not the direction, which I will point out. Assuming that there is a direction, I am not admitting there is a direction that I should pay, even if the award is as per the 2013 agreement, Act. If it is, even if it is under the 2013 Act, there is no direction that I must pay the amount. Therefore, now look at the directions. First, respondent number 2 and respondent number 3 shall constitute a board to reassess the compensation. So direction is to respondent number 2 and 3. I am not respondent number 2 and 3. Correct? With the petitioners in writ petition say are entitled to for acquiring this land at so-and-so as per the 2013 Act. So the direction to constitute a board is to respondent number 2 in the first writ and respondent number 3 in the second writ. There is no direction to NHPC, my lords may kindly note. Respondent number 2 in the first writ is State of Arunachal Pradesh, represented by Secretary Land Management, Department of Land Management, Government of Arunachal Pradesh. And in the second one, respondent number 3 is Deputy Commissioner, Lower Dibang Valley District, Roing, Arunachal Pradesh. I am not these two respondents. The direction is specific to these two respondents. And board shall be constituted with adequate representation of the NHPC. The board shall assess the compensation in each of the component as specified in the first schedule of the 2013 Act in Seratum, and further take into account the provisions of Section 29(2) of the Act of 2013, which provides for determination of value of things attached to the land or building. So how the compensation is to be made, how it is to be assessed, that is contained in clause C. The respondent 2 and respondent 3, on his satisfaction about compliance of all the provisions in assessing the composition by the board, so shall pass the award incorporating 12% interest per annum on the market value of the land provided under Section 30, subsection 3 of the 2013 Act. Aforesaid exercise is to be carried out within a period of 3 months from the date of receipt of the certified copy of this order. To facilitate the reconstitution board fresh assessment, pass fresh awards, the impugned award dated so-and-so approved by the set aside and quashed. Yes. Now, my lords may kindly have a look. 3 months from the date of receipt of the certified copy was the order passed. This order was passed on 12th of February, 10th of February 2025. 3 months were expiring on 10th or 12th of February because certified copy might have gone 1 or 2 days on 12th of May 25. The contempt was filed on 14th of May 25. Now kindly have a look at the contempt and the petitioners in the contempt. The contempt was that you have not constituted the board within 3 months. That is the contempt. There is no contempt application saying that in future an award will be passed and you're not going to not comply with, and therefore the contempt application was filed that you constitute. You're not constituted as per the direction. Of course, it was extended, the period was extended. I'll come to that a little later. Now have a look at the cost title of the contempt petition. Now kindly have a look, my lord.
Yes.
As for the petitioners are concerned, I'll forget. I'm not concentrating on the petitioner. I'm kindly look at the respondents. One is Sri Gaurav Kumar, General Manager, NHPC. How is he concerned if the board is not constituted? How is he concerned if the board is not constituted on May when the petition was filed? To put pressure that they succumb to their illegal demands, even if the order is not as per the 2013 Act. We'll call you for contempt. We'll call you for contempt. Put pressure. You agree. Don't fight the litigation. This is the nature of this litigation. Why is he made? What is the direction that he has flouted in the petition? Therefore, this is a gross abuse of the process of court. Filing a contempt application against the person who has nothing to do with the order of 10th of February. And on 14th of May, when the application was filed. Second, third, I can understand. Then kindly have a look at 4. Rajkumar Chaudhary, Chief Managing Director, NHPC. How is Rajkumar Chaudhary, Chief Managing Director, involved? On 14th of May, when the award is not even passed which was passed in August. If this matter was heard on that date, your lordship would have said, these people are wrongly joined. There's no direction against them. Why have you joined them? The cause of action against 1 and 4 had never arisen on that date. Then kindly look at respondent number 5. Shri Lalitendra Kumar Tripathi, Executive Director, NHPC.
Yes.
So 1, 4, and 5, no directions were given, either general or specific. I've read the direction. There is no directions are given to respondent number 2 and 3, who are concerned with Arunachal Pradesh government, not with NHPC. Yet, because to put pressure on NHPC, they were wrongly and maliciously and malafide joined their parties. Now look at what he says in the petition. Now, kindly come to page 8, para 4. What is the contempt that is alleged in the petition? My learned is traveling beyond the pleadings. He's a senior. I don't want to attribute anything to my learned, but beyond the pleadings he's traveled. That the common judgment and order dated 10th of February 25 was passed in the presence of respective counsels of all contesting parties. All right. In any case, the petitioners, after receiving certified of the common judgment and order dated so and so, immediately forward the same to the respondent authorities. More particularly, respond number, kindly have a look. More particularly, respond numbers 2 and 3. Why? Because respond numbers 2 and 3 were supposed to comply with. My learned friend knows that the compliance is to be by respond numbers 2 and 3, not by 1, 4, and 5. Therefore, it was sent to 2 and 3 only. In the said communication, it was also urged to complete the entire process within a stipulated period of 3 months, as provided by the Honorable Court in its judgment and order. Additionally, Director Land so-and-so issued letter to the respondent requesting necessary action. So again, additionally, Director of Land Management on behalf of respondent number 2 issued a letter to respondent number 3 requesting necessary action pursuant to judgment and order. So naturally, because number 2 and 3 are required to comply with the directions, no such letter was written to 1, 4, and 5. Including constitution of board to carry out a land property survey, prepare the draft event, submit the same to government for approval. Thereof, the petitioners also submit a representation to 1 and 5, forwarding the letter dated so and so, further requesting to coordinate with the office of respondent number 3 to ensure timely completion of the process of preparing fresh award. Completion of process. Completion of process was to be done by 2 and 3, not by 1, 4, and 5. Now kindly have a look at para 5. The petitioners also attempted to participate in the assessment of land, and however, they were not permitted to take part in any survey. They did not. This Honorable Court never allowed them to participate. Private parties. So they were hindering the process. Of survey and preparation of the award. Only communication made to the landowner was a letter dated 3rd of April 25, which merely invited them to a meeting scheduled on 4th of April 25 to discuss the modalities and procedures for preparing the award. The said meeting, NHP officers were not present. Kindly have a look. NHP officers were not present. Everything was being done behind my back. I have a grievance even as for the state government. Therefore, now kindly look at the prayer, Manoj. At page 15. Institute contempt of court proceedings under section 10 of the Contempt of Courts Act 1971 against the respondents contemners for willful and deliberate violation of the judgment and order dated 10th of February 25 passed in by the Honorable Court in so and so, so and so. Punish the respondent contemners under section 12 of the Contempt of Courts Act so and so, and full line of the contempt rules. So their prayer was that you're not constituted the board, you're not done anything, you're not passed the award. It was not that award has been passed and that the award has not been fulfilled, the award has not been complied with, the payment is not made as per the award was never the grievance. This is the first order passing the contempt. So by suppressing material facts, that respondent number 1, 4, and 5 at that stage in May had nothing to do about this. They filed this application. And the first order was passed on 15th of May 25. Kindly have a look at the order of 15th of May 25 when the award was not even passed. Heard Sri S.R. Rabba, learned counsel petitioner, who by means of this petition has alleged willful disobedience of common judgment order dated 10 to 25 passed and so and so. Learned counsel petitioners drawn attention of this court to the representation submitted by the petitioner 13 to 25. Issue notice returnable by 4 weeks. So notice was issued in the month of May 25th, on 15th of May 2025, when the order was not even award was not even passed. When the award was not passed, when respondent number 1, 4, and 5 had nothing to do with the constitution of board, they misrepresented to this honorable court and got an notice issued against 1, 4, and 5 who had nothing to do with the matter. Had it been pointed out that the directions are not with respect to 1, 4, and 5 on 15th of May, probably this court would not have passed the directions. Now kindly have a look. That was delivered after the court. Now kindly have a look at the order of 6th of November 25. So the purpose is different. Vindictive purpose, pressurizing tactics to say that even if the award is wrong, you don't challenge the award, otherwise we'll haul you for contempt. Highest officers will be called for contempt. Put pressure. Now kindly look at what was submitted on 6th of November 2025. Heard Mr. D. Das, learned senior counsel, assisted by Mr. I. Das, learned counsel for the petitioners. Also heard Sri S. Tapin, learned senior government advocate for respondent number 2 and 3. It is submitted by Mr. Das, learned senior counsel for the petition, that the deputy commissioner already complied with the court's order. So order has been complied with. What is his understanding? That on 6th of November 25, the order has been complied with. If the order is complied with, there can't be any contempt. That is a statement made in court and recorded in court. But the oblique purpose will not be served. If I look at the other submission which is made, it is submitted by Mr. Das, senior counsel for the petition, that deputy commissioners already comply with the court's order. If the court's order is complied with, where can there be any contempt? A question that I'm asking myself. This petition should have been closed at that time because of the statement of my learned friend, but it was not closed because of the oblique motive. Here, to put pressure on NHPC. Because NHPC is acquiring lands, etc. So if you do something, even if you're not done, we'll call you, haul you for contempt. Now look at the further statement.
Mr. Razo, why this oblique motive is attributed to the learned senior counsel?
I'm not attributing to the, I'm saying to his petitioners. If that is so, I'm not attributing. I'm sorry if that is the impression that I conveyed. It is to the petitioners, not to the learned friend. Of course, I can never attribute to the learned friend. Yes,
No, even to the petitioners also, you see, the petitioners have been suffering since the year 2018, when the initial award was passed.
That is on merits of the matter. That is on merits of the matter.
Are they not suffering?
I'll address my lords on the merits as far as what has happened for 8 years, etc. I will address my lords on merits. Today I am on contempt. I'm concentrating on contempt. I'll come to the merits of the matter subsequently when I address my lords on the merits of the case. What happened? Why, whether they were left high and dry? What is the situation? I'll address all that. I am not for a moment saying that victims should not be compensated. That is never not my endeavor. My endeavor is that whoever is the victim has to be paid compensation, adequate compensation, not excessive compensation, has to be paid, reasonable compensation has to be paid. No doubt about it.
Mr. Raju, you see, the grounds you have taken in the writ petition speaks otherwise.
I'll come to that one. Let me address this first, then I'll come to the writ petition.
You are blowing hot and cold at the same time.
No, I'm not blowing hot and cold. I'm sorry. I'm sorry if that is the impression carried. I'm not blowing. I'm sorry.
No,
I am not for a moment saying, even if my clients say, even if my clients say that compensation which is payable is not to be paid, I will be the first person to object. I will be the first person to object. I will not even tolerate for a minute if my clients are wrong and deprive persons who are required to be paid compensation, not paid compensation. That is not my case. If that is so, I will not appear in the matter. That is not my case. My case is clear that there is no contempt, but surely I will not buckle down on the threat of contempt when there is no contempt. No amount of pressure of contempt will buckle me down. That is my submission. Now kindly let me read further what I was reading. It is submitted by Mr. Das, learned senior counsel for the petitioners, that the Deputy Commissioner has already complied with the court's order. On this statement, the contempt should have been dismissed. Court's order has been complied with. However, the contemptor respondent numbers 1 and 5, who are general manager NHPC and executive so-and-so, have not appeared before the court. So just because they have not appeared, call them. Continue the contempt. This is not the purpose of contempt. I'll read judgments and judgments. The contempt is not for humiliating somebody by asking him to come and remain present in the court, even when the order is complied with by the person who is supposed to comply with, and persons who are not supposed to comply with are supposed to come to the court just because the petitioners want something. Have not appeared before the court, but though the additional affidavit has submitted Mr. Das Senior, notice have also received by the contemptor respondents 1 and 5, and to the extent they have also submitted certificate issued by the postmaster. I have demonstrated that 1 to 1 and 1, 4 and 5 nothing to do with the order at the stage when the contempt petition was filed. Mr. Das, learned senior counsel, submits that he may be permitted to issue notice to contemptor respondent number 1 and 5. How I become contemptor? What part of the order I have disobeyed? Nothing said in the petition excepting a statement made. This is made after saying, not a whisper said. Learned submit that he may be permitted to issue notice to the contemptor 1 and 4 through Dasti mode. Submitted that as per the order of the Honorable Supreme Court passed in contempt petition so-and-so, Dasti sir is also permissible in contempt proceedings. Considering the submissions made by the learned senior counsel for the petitioners are hereby directed to take steps for service through Dasti mode, and affidavit in this regard shall be filed. List the matter on 10th, 11/25. Further, considering submissions made by learned senior, liberty is granted to file an interlocutor for implement new incumbent as respondent number 3. Therefore, although the order has been complied with, which required the contempt petition to be dismissed on an admission made by the other side insists that respondent number 1 and 5 should be hauled up before this honorable court. For what? It doesn't even say there's an award passed and they're required to comply with the award. If that was the case, if that was what was implied in the earlier judgment, the statement would have been made, yes, sir, the award was passed, they have not complied with the award. Nothing. On the contrary, it says the order has been complied with. If the directions were to comply with the award, if and when passed, the submission would have been made, sir. Number 2 has complied with the order, but there's one portion of the order which is still not required to be, complied with, and that portion is fulfillment of the award. That is not the submission. The submission is, despite compliance with the order, haul 1 and 5. For what? For what purpose? There is no statement in the petition that the award has been passed and you're required to fulfill the award. You have to abide by the award. Nothing. That 1 and 5 have not complied with the award. Nothing. Not even at the time when the statement is made to haul up 1 and 5. Nothing. Well, you're aware, contempt is between the court and the contemptor. But in this case, it is glaring that only for the purpose of putting from the facts, I'm not attributing anything to my land. From the facts, it is clear as daylight that respondent numbers 1 and 5 were sought to be hauled before this honorable court, despite the fact that it was an admitted position that the order was complied with, only for the purpose of putting pressure. If the order is complied with, how can the contempt petition survive? the contempt petition cannot survive. Now, by
Oh,
means
no.
of some ingenuity, you are now trying to
Mr.
make it.
Raju, you see, no, Mr. Raju, you see, passing the award is not the end of the matter.
I'm not saying no.
Is
I'm not saying no. I'm not saying no.
Then what is the
But
next
there is
step?
contempt. There is no contempt on the date the petition was filed. My lords are, I'm sorry, my lord, I'm not clear. What the petition, writ petition about the award is different from the contempt. I'm arguing contempt, which is to be looked at it from a different angle. Contempt is always disobedience of an order in a civil contempt or breach of undertaking. And when the person who himself says that the order has been complied with, where is the question of contempt? I am only on contempt. Therefore, then which are two mutually exclusive topics, writ petition and contempt are exclusive. I am arguing they're different compartments. I'll come to my writ petition when I argue the writ petition.
Yes.
I am on contempt. I'm not saying that the award, if it is correct, etc., is not to be complied with. Those submissions regarding compliance of the award, I will make in the writ petition. Why the award is bad, it doesn't require. But my intention is manifest from the fact that I have deposited the entire amount of the award in this honorable court. Voluntarily deposited to show my bona fide, despite the fact that I don't agree with the award. But may I continue tomorrow? There are one or two matters which I have to. May I continue tomorrow?
At what time?
I have 2G. Tomorrow the court is working there, my lord. There is a holiday here.
Yes. Tomorrow is working day.
Yes, tomorrow then 26 day. My one matter is at 4:30 in the Karnataka High Court. And any time before that, I will come and argue, my lord.
Anyhow, matter is being parted. So your lordship can take up this matter whenever it can be taken to Guwahati also. Parted, it can be taken to Guwahati also.
Okay.
Parted can be taken to Guwahati also because ultimately parted. Parted, if it is parted, then your lordship can take to Guwahati
I have no
also
objection.
and the matter can be heard.
Forum. I am not.
Yes.
I do not have any.
Only my learned friend, Mr. Ratan is there.
I want.
We invite him.
Mr. Ratan can appear through
Yes,
the
yes, yes.
I am not saying that whether it is taken to Guwahati or here. I am.
Okay, Mr. Raju, you suggest the date and time also.
Yes, okay, diary. May I submit a short note so that it is easier for my lords to comprehend the matter when it comes up next date?
Yes, no problem. You can submit.
On Monday, it can be taken if it is not inconvenient. Monday, my lord, can it, Raju is, or my learner, this court, if it is inconvenient, on Monday also it can be taken.
No, I'm not there Monday.
At 2 o'clock.
Tuesday, my lord, Tuesday.
Tuesday.
Tuesday is the first session, my lord. The second session.
Yes.
First session. Okay.
Calcutta.
10:30 at 10:30.
10:30.
No, I'm going physically to Calcutta. I'm sorry, my lord.
नहीं ठीक है 30 को जा रहे हो अरे तो हम
अरे 30 एक दिन चल जाएगा तो. हाँ? Just a minute, man. Just give the date.
let's decide it.
3rd April. 3rd.
Too long date will be difficult. Your lordship is hearing this matter. That's why.
3rd April, my lord. 3rd April. I'm not saying. You can have a look at my diary. I'm packed with matters. 3rd April.
3rd April.
10:30. Amar holiday nahi.
3rd April.
Yes, 3rd is Good Friday, I think.
17.
It is a holiday, I think. Good Friday.
17.
3rd is holiday.
You have to come alone. Raju has to come alone on 3rd.
You want to? I can't come. I'm so. I wish. I'm told.
Why
that
don't you come?
I'm
Well,
told that
I am
notice.
suggesting
I want to come to notice. I love notice, but I'm not able to come.
he loves to go to Calcutta, but he will not come
I
to
don't go to
Guwahati.
Calcutta. The judge, the learned judge says I want to hear you personally. So the learned judge requested me.
So can it be on Monday? It can be because Monday is 32nd of
7th April, my lord.
Monday. So it will be too long. Or it will be close again. 7 April is too long. Monday, can it be on 2nd of, my lord? 38th.
Monday,
Monday.
I'm in Calcutta, sir. Monday, Tuesday, I'm in Calcutta.
Monday. Wednesday, can it be on Wednesday, my lord? Wednesday?
Wednesday, okay.
Wednesday is better. Wednesday and Thursday.
Wednesday in the second half, doesn't matter. First April.
Wednesday.
1st of April.
First of April.
1st of April.
Yes.
Okay. Okay. Third, Mr. D does learned counsel for the petitioner. Learned senior counsel assist the Prime Minister. I does learned counsel for the petitioner. And Mr. S.B. does learned additional solicitor general for the contender number 1, 4, and 5. And Mr. Ratan for
Madam, I'm with the content, Mr.
I do not know whether the notice has been issued because the order says class for 1 and 5. Only. I don't know whether 4 notices has been issued.
Who entry?
1 and because the order says 1 and Mr. Das asked for 1 and 5.
No, I think Mr. Tiwari has appeared also. There is some order which has been passed by this court.
Because your prayer was issue notice to 1 and 5.
No. See the order.
no notice was issued to all the respondents, all the contenders.
Yes, if your lordship looks at the order of 13/11/2025, 13/11/2025.
6 and 7.
Peruse the order, the response 6 and 7 have been impleted. Lordship got it 13/11.
Yes.
Tiwari learned so and so issue notice. At this stage, issue notice on newly respondents, respond number 6 and 7. Now please see at paragraph 6. I'll not read my look. Let's see.
1, 4, 5, 6, and 7.
Yes.
Okay.
Yes.
Okay. Heard in part, list the matter on 1st of April. The second half.
In the IA, I do not know whether a notice has been issued in the main matter for these persons. I'll have to check the record. My lord will say I'm appearing for NHPC officials.
Okay. NHPC officer.
Accepted by Mr. K. Saxena.
I am also objecting.
Mr. Yadav,
Can't be implemented through an
so do we fix it first half or second half?
second half.
Second half at 2 o'clock.
It is working.
Okay. 2 o'clock.
Grateful.
Along with WPC number?
Yes, 58 of 2020.
58 AP 20.
Petition may be detailed. I'll argue the contempt. Writ petition is separate.
No. Detect is, let him argue, let it be remain with the WPC 3. It has got connection. Bearing, it will not be detected. Please remain with, yes, contempt, I will show it, my lord.
Okay.
Yes.
Okay.
Yes.
Next item.
Item number 5 to 7.
My lord, I had a word with the executive engineer and also the superintendent engineer. Today was the last for this particular project. 3 bidders have participated but has not finalized. I have asked them not to finalize.
Yes, all right.
Because if it is stayed, that things will get lengthier, my lord. So
No, we will not stay.
Yes.
But we will extend the time of filing the tender by the petitioners here.
only if they have obtained the tender
Bid document.
bid documents. They have obtained.
You have already obtained?
We have.
Okay.
Even otherwise, since my lord is extending the time, we'll be at liberty to obtain the bid document also, my lord. Since time will be extended, my lord.
Because in that event, other persons also might, because it is their contention that they have obtained the bid documents. If they have already obtained, only for submitting the tender, it was less.
During the first step, they have submitted that they have obtained the bid document.
Yes.
Yes.
Then
That will do
what
also.
liberty is necessary?
That will do also.
So,
And learned counsel for the petitioner, my lord, Pirina has sought for an apology since he had to rush for the medical, since there's a possibility of his wife being suspected of cancer, So
Possibility of?
suspected of cancer. So he had to rush to the medical. So that is the reason the learned counsel Pirina could not appear now.
No, that's all right. What happened?
Suspected cancer, my lord. His wife.
Okay.
His wife. That is it.
Mr. Nayars.
So he sought for apology, my lord, for not
Okay, no
appearing.
problem. No problem.
And my lord, and it may be observed that this will not be a precedent. Otherwise, again, other bidders, they might tomorrow come and say that we want also the similar extent.
Okay. No problem. We will extend it by 2 days?
My lord, today is 25, my lord. 26, 27.
Yes.
And 28, 29 is holiday, my lord. Till
Ma-
30 or 31, my lord. At least.
And let that be submitted even on a holiday, my lord. They let it be.
Until 29, my lord. If they are saying that we can submit on holiday also.
Holiday, where you will submit it?
They are
Physically or by?
physically, my lord. They are making
It
a
is to
submission that they will be
physically
allowed.
Physically?
Yes.
Okay, up to 28?
Yes, madam.
28. In all the 3 matters?
Yes,
my lord. Same matters.
Okay.
I let me observe that this will not be a precedent. So that otherwise tomorrow.
Yes, 2 matters are there.
Okay.
Grateful, my lord.
Item number
Always, madam.
33.
Your Lordship, this matter may kindly be adjourned today as the conducting counsel is on leave.
Okay.
And
Your name, please?
J. Ninu
Then Nino, learned counsel appearing on behalf of?
N. Dungan.
Ms. N. Dangan, learned conducting counsel for the petitioner.
Your Lordship, I have also been instructed to inform this court that affidavit in reply has been filed and 3 weeks' time may be granted for admission hearing.
Submits that conducting counsel Ms. Dangan is out of station. And he further submits that the pleadings in this matter has already been completed and the matter may be listed for admission hearing.
Admission hearing after 3 weeks.
After 3 weeks.
Yes.
Mr. Riam for the state respondents present.
Yes,
Accordingly, taking note of the submission of learned counsel for the petitioner, the matter is then adjourned to be listed after 3 weeks under the column admission hearing.
Yes. Much obliged.
Item number 37.
Good outcomes.
Yes, Mr. Nabam, you have received any instruction?
Yes, Lordship. Is the Executive Council 63, the decision, those recent appointees to under CS scheme to the professor, that is Executive Council 63.12. They were appointed under CS scheme from associate professor to professor. So what happened, my lord, here, they were qualified. So screening test committee qualified them. That's why their case was considered. And this was passed on 18/9/2025. But in his case, he's also a faculty member, but in his case, he joined in university 2015 and he's seeking for retrospective effect from 2018. So 2018, as per 2018, he filed the application, but his application was rejected on the ground follow this document they've given in the instruction. Report of the re-verification of CS appointees regarding. So here, page number Page dated 27 to June 2020. Order, the page number 7, my lord. Page number 7.
Yes.
In continuation to the application submitted by the Bira's faculty of promotion under CS, administrative approval has been accorded that following faculty member of the for resubmission of the press application. So this was the order. The serial number 1, Dr. Satish Kumar, Department Education, present cadre associate professor, and promoted sought to be a professor, level 14. So there after what, my lord, thereafter, page number 10, my lord. Page number 10. Page number 10. This is the letter issued by the director in charge IQAC. It's letter to the Vice Chancellor, Rajiv Gandhi University, Ronohill, Doimok. Subject request of Dr. Satish Kumar, Associate Professor, Department of Education, for giving an opportunity to fill up a CS form as per 2016 regulation regarding reference also. Sir, with reference to the subject cited above, I want to state that Dr. Satish Kumar joined this university as associate professor in the Department of Education on 6th August 2015. He was eligible for post of professor with effect from 6th August 2018. The assessment period for him was 6th August 2015 to 5th August 2018. However, the interview was delayed and it was conducted in the month of May 2021, and the result was declared in the month of June 2020, where Dr. Satish was unsuccessful. As per the provision of UGC Regulation Clause 616 Roman 3 clause, a cadre candidate who could not succeeded a past assessment have to wait for a residential period of 1 year for reapplying for the same. However, since Dr. Satish Kumar was assessed for the period of 6th August 2015 to 6th August 2018, he may be allowed to apply for CAS promotion of 6th August 2019. Therefore, Dr. Satish Kumar may be considered as eligible for the reassessment under UGC Regulation 2016. So this was the letter issued by the Professor Utpal Bhattacharjee, Director IQAC. Then, my lord, what happened here? Again, one letter, dated 24 September, page 11, my lord. Dated 24 September 2021 to Dr. Satish Kumar, Associate Professor, Department so-and-so, request for promotion under CSM. With reference to letter that number nil dated is cited above, I am directed to inform you that competent authority permitted you to apply in fresh format as per UGC Regulation 2016 for promotion under CAS from level 13A professor to level 14 professor. So this was the issue issued by the assistant register establishment RGU with approval of the competent authority. And now let's see here what next page, page 12. 24 February 2023. In pursuance of the 49 Executive Council meeting, resolution of EC 49.04 held on 24 February 2023, Dr. Satish Kumar, Associate Professor of Education, has been promoted under CAS to the post of professor with effect from 24 to 2023 in the Department of Education, Rajiv Gandhi University. The fixed pay fixation will be done as per university UGC norms. So this was the appointment order made on 2023, the 24th February. So now, Lordship, what happened? His claim is that he should get the financial benefit of since 2018. So we are denying because 2018 thereafter interview screening committee conducted the interview, but he was disqualified because his form was rejected because on ground of that he could not fulfill the criteria. So to promote from associate professor to professor, there is some criteria that screening committee has to examine the fulfillment. So his application was rejected. That was the ground. And thereafter, his case was considered on 2023. Now he is engaged as a professor from 23 to 26 till now. So he's getting the benefit, all benefit from 2020, 24 July 2023 lordship. Now he's claiming is that he should get the financial benefit from 2018, which we are denying because he was not qualified. Though he claimed that eligibility is there, he joined in 2015 in university. Then thereafter, after 2018, after 3 years, CSP as per career advance scheme, the associate professor can promote to the professor on ground of after qualifying the screening test. But his case was rejected on ground of non-fulfillment. And I'll see the rejection.
Order. Is it part of your affidavit?
Lordship. This is my part of my affidavit.
Okay. And next, sir?
Lordship, I'll just find out. Election committee. Lordship, here, page number 35 of my affidavit in opposition. 35. Now see the selection here, Department of Mathematics, then Department of Education, second below, Lordship, associate professor, so and so and so and so. So without promotion without interview of assistant professor in various level of different department instituted under CAS. So total of 14 they were there, and thereafter here below, the mark is there that selection committee did not recommend for Dr. Satish Kumar Kalhotra for promotion to professor under CAS. However,
what is the reason?
Reason is, Lordship, just see it was here.
So you see, without interview, some of the assistant professor, associate, assistant professors are promoted to different level, various level of different department. So why his case was rejected?
Lordship, there is some some criteria is there.
Criteria.
Criteria is there.
Yes, where it is mentioned?
Here in my page number 11.
11 of?
11 of the affidavit opposition, my affidavit opposition.
11.
Yeah, 11.
Okay. Yes, number 11.
2018 regulation. This was 2018 regulation. UGC 2018 regulation. Page 11. 6.3, Lordship. 6.3. The criteria for promotion under career advance scheme laid down under this regulation shall be effect from the date of notification of this regulation. However, to avoid hardship to those faculty members who have already qualified, he was not qualified at the time, though he was working as a associate professor and likely to qualify shortly under the existing rule. A choice may be given to them for being considered for promotion under the existing regulation. This option can be exercised only within 3 years from the date of notification of this regulation. And thereafter, there was one, I'll just find out.
Where is the ground for rejection of his candidature?
Lordship, let me. incomplete application was there. Concepts, first application was filed on Annexure 1 Lordship, page number 12.
Page number?
Page number 12. His application. Affidavit, in my affidavit Lordship. This was his application. So
Page number?
Page number Lordship, page number 12. 12 to 20. This was the past application.
No, this is the body of the writ petition.
Affidavit, in my affidavit.
Page number?
Page number 12, Annexure 1.
Yeah, annexure.
Annexure 1. One series. This was the
12.
past application.
Yes.
Because to promote from associate professor to professor, the one applicant has to file an application.
Yes, he has filed the application.
He has filed application.
Okay.
So here see page number 24, Lordship, see kindly.
20?
24. And that's 24. See all this cross mark, not properly filed. Page 24. See, not properly filed. And continuously not properly filed. So not
Page number 24.
Page number 24. All cross mark, see? This was all rejected because not fulfilled the criteria. And thereafter, again, he filed another application. This was filed, and thereafter, after filing this application, then what when 19 February 2020, circular was issued from the registrar office. The application are invited from eligible assistant professor and associate professor of the university for promotion under career advance scheme as per University Grant Commission.
Page number?
Page number 32, Lordship.
32.
32.
Okay.
Circular was issued. The teacher staff, the minimum qualification appointment teacher and other academic staff in university and college and other measures for the maintenance of standard in higher education. Lordship, regulation to the higher education and its amendment 2018. Eligible candidates should apply in the prescribed format, application format as per UGC regulation 2016 and application format as per UGC regulation 2018 as per their eligibility criteria. Lordship, eligibility criteria. The application format along with relevant
number?
That is page number 32 only.
30?
32, Lordship.
32.
32. Application received from eligible faculty member of the university for promotion under CAS by circular number 1 dated so and so.
Need not apply.
So and so. Need not apply again. This was the issue. So
no, Mr. Nabam,
Lordship,
you show me any document where it is stated that he fails to fulfill the criteria.
Lordship, that is, I'll just there's one document he was in his petition.
Sir, I have more and more marks above the other candidates. I have 310 points. I have 310. Even they need 110 points. I never rejected from the application.
Oh, Lordship. In affidavit, page 67, Lordship. Page 67.
Your affidavit?
Yes, Lordship. Page 56. 67. Page 67. That is page 64 to 67. Page 64 to 67. Dr. Satish Kumar, Department Education, post applied for professor. So So here, Associate Professor, date of joining 6/8/2015.
Not applicable remarks, application form incomplete.
Lordship, this was the ground.
That
This
is
was the
the,
ground of rejection, yes. Not eligible. Not eligible, eligibility for promotion, not eligible. Dr. Satish Kumar was
and the ground is that application form incomplete.
incomplete. So he was,
No, you see, subsequently he has filed application. He was promoted to the post of professor.
Yes.
So, can only on this ground, incomplete application, his candidature may be rejected. And while some of the teachers have already been given the benefit from retrospective effect from the date of their eligibility. Why the petitioner is denied?
Lordship, there is criteria for promotion. That is screening committee is there. Screening committee, they will screen the candidate. All relevant document, that prescribes the document. The qualifying is there. That,
No, you say subsequently he has filed the application form and he has been promoted, right? Only because of this reason can it be proper to dismiss his claim?
No, Lordship, to be a professor, to post a professor, there is some criteria which he did not fulfill.
Where it is mentioned? Here it is not mentioned.
Sir, can I speak?
Yes.
Sir,
No, let him complete.
Sir,
You
2000.
can speak. Wait for some time. Let him complete.
Lordship, I'll come. Lordship, page number, I'll come to my petition then. From page number 3.
Your affidavit.
Yes, affidavit.
Page number
Page
3.
number 3, para 4. I'll start from para 4. The deponent may to state that subsequent university conduct career advance scheme, in short, hereinafter called CS, interview in regular interval. However, due to national lockdown, SOP guidelines and safety and security of the candidate on account of COVID-19 pandemic and subsequent year, the CS promotion, both interview and non-interview, were delayed. However, delay of conducting CS interview will not affect the petitioner or any other candidate. It is pertinent to mention here that from the date of qualifying of the interview, candidate will be promoted retrospectively. This is there. However, in the instant case, the petitioner was qualified and passed the interview in the year 2023 only. Lordship, that regarding the interview shortlist for promotion to professor in 2020, the petitioner was not called for interview on the ground that under new UGC regulation 2018, evidence of successfully guiding a PhD scholar is mandatory, and in the application of the petitioner, no evidence of successfully guiding a PhD scholar was enclosed in his application, Lordship. And no scholar had been awarded PhD under the guidance of Dr. Satish Kumar at the time of screening of his CSP application. Hence, his application form was incomplete. Consequently, the university authority asked the petitioner to reapply accordingly. Therefore, university authority did not consider the petitioner request for retrospective promotion effect from 2018. Further, university authority in its circular dated 19/2020 had requested all the candidates to apply under UGC regulation form.
All right. That's all right.
Possible. Then
no, here also you see his application form is incomplete. No evidence of successfully guiding the PhD scholar was enclosed in his application, and no scholar has been awarded PhD degree under the guidance of the petitioner at the time of screening of his case application. Hence, his application form was incomplete. So, whether you have guided any PhD scholar?
Sir, Rule 2016 and 10, there is no need to qualify the PhD, to pursue the PhD. 2010, 2016 rule.
2016?
Yeah.
Is it part of the affidavit?
Yes, sir.
Part of your petition?
Yes, sir. Yes, sir.
Page number
178.
178. 78. Yes.
This is to inform all the faculty members who are eligible to promotion under CAS 17 July 2021. Under UGC regulation and guidelines 16 and 18, they may submit their application along with APA and other supporting documents in the prescribed format available university website to the undersigned on 25th of May 2020. 220 तक होना चाहिए. उन्होंने कहा कि 27 तक आप अप्लाई कर सकते हैं. उसके बाद 23 तक का होगा, उसके बाद 24 होगा. सर मेरे पास ऑर्डर है, ये अभी मेरे पास है. हम 2016 तक हम कर सकते हैं, 2023 तक कर सकते हैं, 2024 तक कर सकते हैं. Last line, it may be noted that the option of the application under UGC regulation Act 2016 is valid up to 17 July 2021. New Delhi, 18 July 2018, 77, page number 77, page, para number 6.3. Next, sir, page number 190.
No. This circular does not speak about waiving that criteria.
Criteria.
Page number
178.
No, that's all right. Another. You have referred to another page number?
Sir, page number 179. Sir, with reference to your letter number dated cited above, I am directed to inform you that competent
Page
authority.
number 179.
Ji, sir. With reference to your letter number dated cited above, I am directed to inform you that competent authority permitted you to apply in a fresh format under UGC regulation 2016 for promotion of CAS from level 13 associate professor to level 14 professor. One who apply for the 2016 under rule 2016 and 2010, he is eligible for retrospective effect.
No, that's all right. The criteria that you have to guide one PhD scholar.
Sir, in 2010 and 2016 rule, there is no need to produce PhD.
2016 rule.
Yeah, I shall tell you, sir.
Show me.
Yes. Sir, page number 187. 187.
87.
Yes, sir.
Rule
6.3.
6.3.
Qualification for appointment of teachers and other academic staff in university and colleges and other measures for maintenance of standards of higher education 2010. A choice may be given to them either being considered for promotion under 2010 or 2018. This option can be exercised up to 31st of December to 2023, and the date of eligibility shall be retained and the date of promotion. One more case is there. Mr. Bilal Fiksha, appointed as associate professor in 2007. He got promoted in 2017, in 2024.
Page number?
239.
Mm.
103.5.12 to report the ratify the recommendation of the selection committee for various seeking another academic position for promotion under UC career advancement scheme. Executive Council was informed that on the recommendation of the statutory selection committee, various teaching position or promotion UC career advancement scheme, UC regulation, holding members were promoted under CAS.
Mm.
Number 1, Dr. Bilal Fiksha, City Srinagar. Stages associate professor to professor 23 February 2017. 24 May, the result was declared in 2024. But he got the promotion from 23 February 2017.
No, that's all right. He has been given the promotion with effect from with
Yes.
effect from
Yes.
23rd of 2017.
Yes.
But you show me the notification by which the criteria of guiding one PhD holder
Sir,
is waived.
yes. 187.
187.
6.3. Qualification for appointment of teachers and other academic staff in universities and colleges and other measures for maintenance of standard in higher education 2010. A choice may be given to them either for being considered for promotion under 2010 or 2018. There are two rules are there.
Mm.
Up to 31st of December 2023, date of eligibility shall be retained at the time of at the date of promotion on the date of submission of application, and candidates will be. There is no need to produce PhD degree.
But is it stated here?
Pardon, sir.
Is it stated in this?
Yes, sir.
Where?
So, in this route, they have written there is no question of PhD producing the PhD. In 2018 rule, there is a commercial for producing PhD degree. 2010-2016 रूल में PhD को प्रोड्यूस करना जरूरी नहीं था.
No. While your case was considered, which rule was prevailing at that point of time?
2010.
2010.
10.
2010.
Yes, 2010.
This rule come into force when? This page number 187.
187.
From 23. July 23.
Yes, sir.
Where is the 2010 rule?
Continue, sir. Continue.
No. Is it part of the record?
Yes, sir.
2010 rule.
Yes.
Page number?
Page number 186. Short title and commencement.
No, that's all right. 2010 rule. This is of 2023.
Yeah. Sir, they have written qualification for appointment of teachers and other academic staff in university and college and other measures for the maintenance of standard in higher education 2010. And choice may be given. There are two choices are there, 210, 218. Anyone choice can be considered.
No, that 2010 rule.
Yeah.
Is it part of the record?
Yes, sir.
Page number?
187.
The rule. This is of 2023.
Yeah.
This notification is of 2023.
Rule is 2010.
No, that rule is you have enclosed here.
Yeah. There are two rules are there, sir. 2010, 18. Anyone we can.
In 18 it is compulsory.
Yes.
10 it is not compulsory.
Not compulsory.
That 10 rule. Do you have the copy of that rule?
Yes. Yes, I think so.
Give it to me.
$185.
$185 is a
6.3.
185 is the same rule.
Same, sir. Same.
I am asking you about 2010 rule.
10 rule. This is our first page. 2010 rule, and this is second copy.
Which one? This is Hindi. 2085 is it? It is in Hindi.
University Grants Commission notification, New Delhi, 6th of June 2024.
190.
You are quoting the
190.
number wrongly.
190. Other teachers have got retrospective effect, sir.
No, that's all right.
Yes.
Others got the promotion.
Uh-huh.
You show me the 2010 rule.
Sir, this is 2010 rule, sir.
How it is 2010 rule? This is a notification of UGC 2024.
I shall tell you.
Mr. Nabam, do you have the UGC regulation of 2010?
2010 also. But 2016 I have.
18 is here. I have seen it. 2010 rule.
No, I don't have.
You don't have. This regulation 2000.
Our all teachers are made professors without PhD.
That's all right.
Under 2010. And
Can you produce that 2010 rule
sir,
before this court?
at present, I don't have. I can bring, sir.
You can bring.
Yeah, I can bring, sir.
When?
Tomorrow.
Tomorrow.
Yes.
Okay. Tomorrow in the second half, Mr. Nabam. If you also try to obtain a copy. 2010 rule. Specific on that point.
Okay.
That guiding of PhD scholar is not the requirement under the 2010 rule. Is it there or not? You examine, you let this court know tomorrow in the second half. Heard Mr. Satish Kumar, petitioner in person, and Mr. Nabam, learned standing counsel for the respondent, university. place the matter tomorrow for further consideration. In the meantime, the petitioner shall produce the UGC regulation 2010. Mr. Nabam also tried to obtain a copy of the same and shall produce before this court. And also apprise this court about the requirement of guiding a PhD holder